the Ohio Investigative Unit under the Department of Public Safety. It was previously liquor control years back. Did a lot of vice crimes, Ohio organized crime, drug task forces and task forces. So a lot of variety of investigations, a lot of long-term food stamp fraud, ran the gamut, gambling, drugs, all that.
If you would, share with the court a little bit about what your duties, roles are with the Special Investigations Unit of the Ohio Auditor's Office.
So our office takes in complaints that are primarily theft in office. So any kind of public corruption, tampering with records, things like that. Those are the types of things we receive hundreds of complaints every year relating to different public entities where there may be a theft of funds in some way, shape, or form. Also, other conflicts of interest. We tend to get a myriad of different types of complaints. So we have to kind of weed out what we can investigate criminally, and then there's other items that can just be looked at by the region. And the region will then do, they'll look harder at it in an audit. They maybe have specific items that they'll look at based on what we direct them to look at.
And how do these complaints come to your attention?
We receive complaints, like many agencies, email, phone calls, tips from other public officials. In this case, we received a complaint through anonymous tip.
And how does that, is there a hotline? Is there something
There's a
set up?
hotline, correct, there's a fraud hotline.
And how is that, is there a means by which that information is shared with the community or entities to relay that information to the auditor's office?
Well, public entities are required to go through a annual fraud training now. So there's like, I think, a video that public officials are supposed to watch, and public employees are supposed to report if they see fraud or if they believe there's any type of misdoings on the part of their public employers.
And so you've already stated that with respect to why we're here today, the Auditor of State's office received an anonymous complaint on that tip line?
Correct.
When did that occur?
That was in February of '22.
And what happened from there as far as how you got involved?
So the original complaint came in, I just refer to the timeline that was provided, February 17th of '22, and that was related to bills that weren't being paid. There were some concerns that there were some services that were being cut off. One of those particular ones was like a teacher's program that they used, some sort of a teaching program that they used, and they lost access to that because a bill had not been paid. There was just different bills that we were being told that had been unpaid or late at that time.
From where, by whom?
From the treasurer's office, I'm sorry, from the Wayne local schools, Waynesville, Ohio, Warren County treasurer's office.
And was the name of that treasurer identified as part of that original tip?
Yes, it was, Ronald James.
So that tip comes in February, and an investigation begins, correct?
Correct.
Did that get assigned to you immediately, or how does it end up on your desk from there?
Yes, it was assigned immediately to me.
And what actions did you take at that point in time upon receiving that original tip, that complaint?
I recontacted the complainant to try to see what other information they could provide, and then contacted the superintendent to see what he knew about this potential issue, if any of this has been brought to his attention.
And the focus of your investigation to begin with revolved around what specifically as it related to Mr. James?
Originally,
Yes.
it was the late bills.
Why would that be something of involvement of the Ohio Auditors of State?
Because usually late bills are an indication of more problems behind the scenes, that there's maybe not funds, that there may potentially be a theft. So we look at all of the accounts. We try to research a lot of different avenues. So in our teams, we work with forensic auditors. So very often, there are items, actually in every case, there are subpoenas sent, whether it's to the banks, to the schools, or the other entities themselves sometimes, to obtain documentation. Most agencies provide the documentation that we need to take a look and look further at their accounts to see if there's specific issues we should be looking at, if there's payroll issues, people aren't getting paid. And those were things that we started to see going down the line then.
Were you alone in your investigation of this particular complaint?
No,
Who and how many other folks were involved with you in the investigation?
one other, his name is Darren Batchelder, he's a senior forensic audit manager.
So the two of you worked together as far as investigating what you were hearing about?
Correct.
So what were your first actions, your and Darren's first actions with regard to following up on what you were hearing?
So we took a look at, we asked for whatever documentation they had that they could provide.
You asked who for that
The
information?
superintendent
Of Wayne School?
of Wayne Local Schools, yes, Mr. Dubs. They had provided then some photographs that were taken of items on a desk. It appeared to be bills that were second, third notices of payment, late payment, things that had not been attended to, items like that. And then we followed up then with further interviews of principals, building staff, and then Mr. James.
Now ultimately, those issues of late bill payments, any fines or late fees that are associated with those ultimately did not end up being part of a criminal indictment, correct?
Correct, those will be addressed separately.
But those are things that you found as part of your investigation.
Correct.
Did you have the opportunity to speak with Ronald James, or was that important for you to speak to Ronald James, the treasurer of Wayne Local Schools, as part of this investigation?
Absolutely.
Why was that important to you?
Well, we wanted to find out from him how this could happen, why there might be late bills, what the problems were in getting the bills paid.
And that was, at least the original interview with him, that was the extent of what you kind of were aware of, correct?
Correct.
When was that first interview with and did Mr. James agree to interview with you?
Yes,
Was it by yourself or was that first interview?
yes, Darren was with me as well that day.
And when was that? When was that first interview with Mr. James?
April 28th of 22.
And where did that interview take place?
It took place on Old Dayton Road at the office that they had referred to already. It was a house, not actually on the campus of the school. It was in a remote location around the corner from the school because they were still in construction phase.
Just describe those surroundings as far as the location where this interview took place.
It was a house, a ranch, and when you first walked in the door, it was wide open, and that wide open space was kind of like what would have been a living room converted to Mr. James' office. And then to the left would have been Becca's, I can't think of it, Small's office.
Who
That was
is
his
Becca?
assistant.
Thank you.
Yes.
And so the two of them worked in the same space?
Yes.
Were there any other folks that were working at that particular time during this interview?
I don't recall anyone else being there that day.
And when you interviewed Mr. James, were these, at least Becca Smalls, was she around during that time as well?
Correct.
Was that interview recorded?
Yes,
How was it recorded?
by an audio recorder.
Okay, it's something you had brought to the
Correct.
space as well, okay. Let's talk a little bit about was Mr. James willing to talk to you?
Yes, very.
In fact, you had how long was that original interview back in April with Mr. James?
I'd have to relook at how long it was long. An hour and a half, 2 hours,
At least
maybe
over
more.
an hour, correct?
It was, yes, it was long.
And there were many things that you discussed as part of that interview with him.
There were, yes.
Was there was during that conversation, did you talk about fraud investigations and Mr. James's knowledge of fraud investigations and behaviors of fraudulent behavior?
It was pretty early on that he explained when he understood, he knew who we were, he knew the auditor's office, he understood what our job was, and he explained that he knew what fraud was and that he could probably write a book or teach a course on fraud because he knew quite a bit about it. He talked about the three prongs of requirements for fraud and things like that. So we recognize that he understood exactly, and he's had a lot of experience as a treasurer, so he does know what he's doing in that way.
And prior to working as a treasurer with the Wayne Local Schools, was he also employed in a accounting capacity with outside of a public environment?
Yes, he told us then that he had, he was a CPA, and I don't recall the other three-letter acronym, but he had some other accolades behind his name, that he had other specialties in financial planning, I believe, and that he held an office outside of the Wayne Local School District. That office was over at Grandma's Gardens, and that business took about 99% of his side business.
So with regard to that piece, so you at that point, was the word or name Grandma's Gardens anything that was on your radar at all?
No, not at all.
And you indicate that as part of your conversation with him, he brought up the issue of Grandma's Gardens, at least as part of another business that he did. Is that right?
Correct.
Okay. And you said this was recorded. Is that right?
Correct.
We have what is marked as State's Exhibit number 28A. And so I want to turn to that portion of the interview, which starts at about the 55-minute, 40-second portion of the interview, where he has this conversation with you about Grandma's Gardens. Now, at this time, I would just like to go ahead and play that portion of the interview.
Kevin, would you give me that time?
55:40, we're going to play 55:40 through 58:43.
The view is pretty.
If something's going on.
Or, like, do they come here, or? Have you mentioned Mr. Board President
Jim Byers.
Byers. So you mentioned Mr. Byers asking for help. Have you done other taxes or that kind of work?
People?
Yeah, for people within the district, or like, do they come here, or?
Oh, that's interesting. So is that what they've accused me of?
I'm asking because you mentioned
Yeah.
Mr. Byers having come
I
to.
didn't, never did this here at all, never. I do, probably 1, 2, maybe 3 teachers. When I first got hired, my bonus at General Motors was 3 times what I made. And I don't do this. I'm a certified financial planner. I still have my certificate lapse because it's so expensive to keep on this.
How long ago did you let that lapse?
Probably about a year ago. But I only use that to help for people at home. No. And if people came in to pick up a return, yeah, they've done that. I have my own printer, I have my own software. I do not use school resources, nor do I use company time. And it's an insult if you're insinuating that I'm insulting. Don't do that. Or if anybody says that, they're crazy.
I asked the question that
Yeah.
you opened the door.
No, I didn't really open the door.
Well, you said Mr. Byers
Yeah,
brought your stuff, so.
He didn't bring it
or
here.
his-
He didn't bring it here.
Well, you didn't specify, so I was clarifying if anyone else brought in.
Yeah, I tell you what.
But that's my job, so if I offend
Yeah,
you,
that's
it's
okay.
because that's my job.
Okay.
Okay.
Fine, but I can still be offended. Because the insinuation is no. Hell no. I have an office out on State Route 48.
A separate office?
Yeah,
So do you actually, when you said you let your
Now, let me tell you this,
financial planning?
let me tell you how big that business is. Probably one client makes up 99% of it. I don't really, I'm phasing out. The only time I ever help with taxes is if one of our teachers is poor, divorced, and have her no charge. The mayor of Waynesville I do his for, because he helps in terms of keep the political stuff together, and normally he paying me $150, and it's good to have good relations with the mayors of Waynesville, not for favor for me, but for the school,
But you said the separate office, is it like part of your residence or part of a
No,
separate
no.
actual business? Are you just like
It's part of,
in partnership with other people or something?
It's so small. Under my practice,
Okay.
I work to help a company called Grandma's Gardens. And you will not pays. Next step is there will be no checks to Grandma's Gardens. In fact, all that stuff around the school, not only this school, is free and donated. In fact, he wanted to donate everything from this school because of, yes, I don't have the same card. Oh, you want the MasterCard?
Yes.
You put that there.
The topic of Grandma's Gardens then comes up again later in the interview around about an hour into it, an hour and 20 minutes, is that correct?
After this?
Yes, if I stop there, there's additional conversation about Grandma's Gardens later, correct?
I believe so, yes.
May I ask what date we're on?
This is all April 28, 2022.
Your Honor, if I may, we had a pretrial conference and we talked about the hours and hours of interviews that had taken place for the defendant. You instructed the state to tell me what sections they were used. This was not in it. This has nothing to do with the 2 emails you sent me that we were supposed to review that would be utilized at this trial. I just want to enter that. And the other thing I want to enter is an objection, because unless there's an admission against interest, I don't, this would not be admissible.
I assume that Mr. Harbin's entering this is because Mr. James brought up Grandma's Gardens, which I'm guessing that's why he's bringing this up, is because it wasn't even part of the investigation initially, and then Mr. James is the one that, if I'm correct, Mr. Hardman?
Yeah, I mean, obviously, it shows Mr. James' relationship with Grandma's Gardens, and it's his statement about how connected he was. It's a statement we provided. I thought that we had provided this portion of this interview. Our focus from that original conversation was the conversations about Janae, where he specifically talks about the Janae stuff, and that was the portion that we shared with them in response to that email. But there's another, again, they've had these tapes from the very first original conversation, so.
All right, your objection's noted, so we'll go on.
So looking at we're gonna look at the 1 minute and 20 second to 1 minute and 1 20-second.
This culture and here. No. I probably make, I'm gonna guess 27,000 a year from consulting with Grandma's Gardens, and I do everything from, it's really lectures on business culture and how we're going to approach people. How do you compete with big box stores? And so I've designed, they have food days where they invite clients, and it is successful, one of the best in Southwest Ohio. So in this section, I said design a little garden, and that's where you serve your food so people can find the respite of peace. And there I do their tax stuff, and QuickBooks, so I stay expert at QuickBooks, but there's no, look at it, there's no checks to Grandma's Gardens or,
No,
but he lets me use it office. But let me tell you this.
Gotcha. Well, that makes sense then.
20 people.
So again, at that point, when you met Mr., and just to clarify, so that exhibit, that is your voice and Mr. James in that particular interview?
correct.
And again, at that point, Grandma's Gardens was not a part of your investigation, wasn't something that you had seen or stumbled on as part of any of the documents that you had at that point.
It was not.
This was, just explain how that topic came up as part of your conversation with the defendant.
He just brought it up because he'd mentioned something about Dr. Byers bringing in paperwork, I believe maybe tax paperwork. So that led me to the question about taxes, and he thought I was accusing him of doing taxes, and at the moment, that's not what I was doing. I was just asking, well, does this happen? Do people bring their things? And
Judge should move to strike what she said he thought.
Sustained.
So the conversation was, when you say taxes, it was bringing taxes to the school in order to be done there? Is that the
To the-
allegation he was feeling was being brought against? Well, was that the allegation that wasn't the allegation you were investigating, is that right?
Correct.
Did Mr. James indicate to you that he felt that was an allegation that was being made against him?
Yes,
Okay, I mean, he made those comments to you.
correct,
And that was how the topic of Grandma's Gardens came up.
correct.
In there, he stated that you can see that there would be no checks to Grandma's Gardens, is that correct?
Correct,
That was one of the statements he made to you.
correct.
You've learned that to be, and again, this was April of '22.
Correct.
So this is before what we're here with, but were there actual checks to Grandma's Gardens before April '22 that you saw and found ultimately as part of this investigation?
Later, yes.
Okay. So after this, after the interview in April of 2022, the investigation continues.
Correct.
Tell us what your actions are at that point, what is ongoing with regard to Wayne Local Schools.
So
Let me, because I think there's a lot of stuff
there's
that,
all, yeah,
that we are not here about, correct?
Correct.
So I don't want to get into a whole lot of that.
Exactly.
But there was clearly a lot of documents and paperwork that were involved in investigating a lot of other allegations that were also taking place here, is that right?
correct.
As part of the investigation, looking at these records, did you and your partner observe checks, purchase orders that were of interest to you that Mr. James was issuing to his daughter Janae?
Yes.
How did that come to your attention?
So, when we do a fraud investigation, many times we will subpoena the bank account of the public official or the person who's a potential suspect in the case. We looked at bank statements and bank accounts and looked also through some school. You also look at what access to cash that person may have within their entity. So we looked at checks that may be made to James, to himself. He might be reimbursing himself for something. And then looking for James, we see Janae James's name in there. So Darren, my partner, the forensic auditor, he pulls those, and then we have a discussion with, at that point, it was Carolyn Huber, who was here yesterday, the treasurer now. Had her assistants helping us pull those documents to see what those specific payments were for, the requisition, the train, which is something that was already brought up and entered yesterday, I believe. But it was the documentation for each of those checks that were cut to Janae.
And just so we're clear, you have in front of you this packet of state's exhibits, is that correct?
Correct.
So were you privy and obtained from Carolyn Huber what have been marked as state's exhibits 1 through 9 and the various letters to them as it relates to the payments to Janae James from Wayne Local Schools
It would have been from the treasurer's office.
related to ACT, at least according
Yes.
to those purchase orders and requisition forms?
Correct.
And there were also checks from ACT to Wayne Local Schools that matched up with those particular payments to Janae?
Correct.
Did you endeavor to find out on your own through ACT as to what those payments for to Wayne Local Schools were for?
Yeah, so it was my understanding that ACT,
Objection.
I contacted,
Hang on. I'm not quite sure what she's gonna say yet, Mr. Smith, so I'm
Well,
gonna.
the answer to, it's more than the answer to the question, because that's what they do.
All right, let's start over then, Mr. Hardman. If you will restate the question for me, please.
As part of your investigation, did you reach out to ACT to also find out the reason for these payments to Wayne Local Schools?
Yes, I did.
Okay. And received information from them about that?
Correct.
Did you then make attempts to follow up with either Mr. James or Jana James with regard to that information?
Yes,
Before that, did you also speak with Superintendent Dubs?
I did.
Did you speak with other individuals who were previously ACT test coordinators?
Correct.
Based, and then follow that up with a conversation with Janae first of all, is that correct? You remember if you talked to Janae before you re-spoke to Mr. James again?
Yes.
And what was your purpose for reaching out to Janae James to have a conversation with her?
To ask her about supplemental checks issued from the school
And where did that interview take place?
at the school.
And in an office, in her, I mean, what do you know of Janae's role at the school?
That she's a kindergarten teacher and they were doing kindergarten assessments. I believe we were in the summer and they were doing kindergarten assessments for the students. And I tried to find a good time with the staff to find out when she might have a break to be able to talk to us.
And did that occur on August 14th, 2023?
That sounds correct.
Was that location of the interview, was it around students? Was it in a classroom?
No, I'd asked the principal to allow me to use the room in the school.
And your conversation with Janae James was
Objection.
how long?
Your Honor, objection.
Overruled.
Your Honor, if I may.
Overruled.
refer-
Overruled. Let's go on. Let's move.
Your conversation with Janae James was how long?
Objection, she remained silent. She invoked her right to remain silent.
She did
This
not.
is an investigator.
She did not remain silent.
How long was the interview?
Just a couple minutes.
All right.
That was recorded as well, is that correct?
Correct.
Okay. At this time, we would move State's Exhibit number 28. Can I ask the
I
lady?
object to this. Ending the interview, she said, I'm uncomfortable, I don't want to play, I don't want to be interviewed.
Mr. Hardman, did she invoke her right to remain silent?
She
Yes or
did
no?
not. She said she was uncomfortable about the conversation. She then proceeded to talk to the interview. She never indicated she wanted an attorney. She never, and when she said she didn't want to talk anymore, it was stopped. Actually, it was it was her, our investigator, who asked her, do you not want to talk anymore? And the interview was stopped.
All right. Since this is a bench trial, I'm going to allow it for now because I don't know what it is yet. So it's kind of hard to.
I would also indicate there's been no motion to suppress, nothing brought to this court up until now. This is an interview that they.
Okay. Play it now. Again, listen, I can separate in my mind if I believe it's admissible or not. So we don't have a jury here. So let's just let's keep this moving to some extent.
Be pertaining to is purely related to the investigation into the treasurer's office. And I understand that's your father, Ronald James. Is that correct?
That is correct.
Okay. So there are issues that we have that we wanted to look at and ask you questions related to the ACT program. And really, that's one of the main issues. There's other little things, small things that we have to ask you about, and that's just because your father's in the position he's in, and you're in not really a subordinate necessarily, but you are a teacher within the system. So there's
Okay.
some kind of generic questions, but most of them are related to the ACT program.
Okay.
Okay?
Okay.
Just in your role in that
I just was
program.
the ACT test coordinator, and yeah, that's about all. I just run the ACT program.
Did you want to continue to answer
Well, I mean, I don't know
those
what else to- I
questions?
don't know what else to say.
I don't
like,
want to
about
make
that.
you feel, and I understand how you feel kind of on the spot.
Yeah.
But I want you to understand that our questions are related around your payments from ACT and how
Okay.
that falls. I'm not really comfortable in this room. It's getting hotter, and
Yeah.
I want you to be comfortable. Okay.
Yeah, I'm just not comfortable right now at all.
Okay.
I love my dad. He is the best thing that's ever happened to this school district and has done more for this place than anywhere for the last 25 years. So this to me isn't right or fair to all of what's happening or going on. So I'm definitely not comfortable with whatever is going on and that they're doing with him. It's not right. It's wrong.
Okay. Well,
That's my stance.
gotcha. And our office is in as an objective.
Yeah, because
coming
he's
in
a
from the
stand-up man of
outside.
integrity and honor and loyal and, born and raised here as am I, and so nothing but great things for this school district in every way, shape, and form, so. And better to, this whole campus, his footprint is everywhere.
Right.
The buildings and all of the fields and,
Yep.
yeah, that's all my dad, working hard for the district, so.
Yeah. So our job is just to look from the outside
Yeah.
objectively, and when
It
we
just-
saw some things come through, some payments and things, that's why we have.
Yeah,
to
I've
ask
never
those
gotten any
questions.
types of payments that weren't, the way they were supposed to be, as far as that goes.
Okay.
So I've never gotten any other payments besides my paychecks and, yeah. So,
If you,
I don't know what else to say, but I get my check every 2 weeks like everyone else here. Never anything more.
never anything more?
Never. And I'm honestly insulted that you would insinuate and ask me that.
Okay.
That's ridiculous. I would never get paid anything more than anyone. I have my contract and I get paid every 2 weeks like every other employee.
Okay. Well, it's up to you, again, to continue, but I have some things I can show you.
No, that's just a straight up insult to me and my father to even ask that or insinuate or imply that in any way, shape, or form. In fact, things
Like
have
I
worked
said,
against me from that standpoint. A lot of unfair things, so.
I can see how you might feel that way. I mean, it's not always
I
easy to
mean,
be the child of
I just,
administrator within the system. But it's up to you if you want to continue. I do have some things I can show you to ask you about, and that
I
would be
honestly,
directly related to payments.
I'm just so uncomfortable right now.
Okay.
Really uncomfortable.
Well, then we're done.
Okay.
Okay?
Okay.
Thank you so much. I really appreciate
Okay.
you taking some time out. And I
Thank
know
you.
it's a busy week with
Yes, I have been
kindergartners.
working all day long, so, yes.
All right, well, you take care.
Okay, you too.
I'd renew my objection, Your Honor.
It's overruled.
At that point, when you spoke to Ms. James, you obviously heard her talk about not receiving any payments other than her biweekly paycheck. Did you know that to be true?
No,
Because why? What did you know had taken place?
because we'd seen the other checks from the school district to her with the notation in the memo regarding ACT.
Recently, actually very recently, you've also received or became knowledgeable of some emails involving the ACT and Ms. James and Mr. James. Is that correct?
Correct.
I want to show you in front of you is State's Exhibit number 20. Go ahead and pull that out. Was this one of those emails that you've had the opportunity to see?
Yes.
That email is between who?
It starts with from Janae to Ron James.
And Janae is.
Janae James to Ron James.
And what is the question that Janae James asks of Mr. James?
On Tuesday, September 29th of 2020, she asks, subject is ACT, what do I bill ACT for building usage? XOXO.
And Mr. James responds back, correct?
He responded back 3 minutes later with $350.
And then she responds with a thanks, correct?
Correct.
You then shifting gears a little bit here, did you also learn sometime in August of a contract that got entered into between Wayne Local Schools and Grandma Gardens?
Yes.
How did you learn of that?
I think it was a, excuse me, it was a dual time, between learning that Mr. Dubs was going to be resigning and that another one of the people that were continually in contact with me from the school district mentioned that there was a mention at the school board meeting of the introduction of Mr. Reinhardt to provide landscape work for the new building, for the finish. And that was presented at that meeting.
And did you learn that there actually was landscape work performed by Grandma's Gardens
Yes,
in late 2022?
correct.
What else did you have conversations with board members about how that contract took place?
Yes, I did.
And as part of those conversations, did it involve whether or not Mr. James had any involvement in the obtaining of that contract?
They said that he had, the statement that was made was that he had brought his friend, Mr. Reinhardt, to,
Sustained.
Right.
Just yes or no? Did you inquire of them as to whether or not Mr. James had some involvement in obtaining that contract?
yes,
So when you met, you then had an opportunity to meet and speak with Mr. James again in October 31st, 2023?
correct.
And at that point in time, had you investigated this Grandma Gardens contract? Is that right?
Yes,
Were aware of the ACT payments to his daughter Janae?
correct.
And between that original interview in October 23, there were other contacts with Mr. James, is that right?
Correct.
Just briefly talk about what kind of contacts that were, how often that was.
Mr. James would send support for different questions we had. Until he retired. But he retired then or left at the end of October. What was your final date that you asked?
Was that October 2022?
That was October of '22.
So I want to, so prior to his retirement from the school, so.
So
from-
after the retirement, no, I didn't have other contact.
Prior to his school retirement at the end of October, he was answering questions from you.
Yes, yes.
Would you describe him as cooperative? How would you describe his working with you throughout this investigation?
I would describe him as cooperative but defensive. He would go into great detail and explanation as to maybe why he felt, why something was done, and often provide other individuals who would be responsible for the actions that had occurred.
You then had the opportunity to speak to him October 31st of 2023. Where did that interview take place?
At Clear Creek Township Police Department,
And he willingly came to that meeting with you?
he did, and he brought his wife, Chris.
Okay. And he willingly engaged in a conversation with you on that day as well, is that right?
He did,
Did you record that conversation too?
I did.
As part of that conversation with Mr. James, did the issue of the creation of purchase orders, how that system works, come up during that conversation?
It did.
I'm going to direct your attention to State's Exhibit 27B, which is the interview with Mr. James on October 31st.
B is in boy.
As in boy, yes. Page 27. Yeah, no, I'm sorry, 28B. This is 28B.
Wait.
October 27th, right?
I don't have a 28B.
Yeah, I think it just says 28 on
Okay.
your sheet, Judge. There's a 28A, which was the first interview we just
I got
heard,
you, okay.
and then this would be 28B.
Leave, right? For sure.
I'm going to go ahead and turn this to the 2-hour How long was this interview with Mr. James on October 31st? I guess we'll ask that question first.
I think it shows, it goes to 2:46.
So about 2 hours and 45 minutes?
Sounds about right. It's long.
You must have a different tape.
But this
You
is,
leave.
no, it's a 4 hour, yeah.
3 hours.
I was gonna
it's
say, I
over
was
3
looking at,
hours.
thank you. Oh, it was where it stopped. It showed what was left. I'm sorry.
How
Yes.
long was the
It was,
interview?
it's 3 hours and 54 minutes and 10 seconds.
An almost 4-hour interview.
Thank you. Yes, yes. I'm sorry.
We're gonna go ahead and look at the 2 hour, 5 minute, and 30-second mark.
Is there a question on the table, Your Honor?
I don't know.
I don't either.
We're gonna play his interview.
Okay. Proceed.
Your Honor, unless it's an admission against interest, you just don't play interviews.
Well, I don't know what the I've never heard the interview, so I don't know if it's an admission
Well, you
against
would
it.
think there'd be a question, there would be a predicate
It's a
for the
state-
playing of something.
The statement of a party opponent, first of all, with regard to the state, and I believe it is a statement against interest within the statement itself.
All right, play the portion, please.
And there's never denied, not one.
So we're talking about that in the purchase order system. So we reviewed the entire purchase order system, and that's why we kind of clarified some of those extra questions for you. You explained in our first meeting how it worked, and when we went through SWOCA and everybody else. And we really appreciate you explaining all of that. The building secretaries use strategic solutions software.
That's us, that's the same thing.
In which they enter a requisition to purchase items, correct? Then the requisition is sent to the respective building principal,
Yes.
who then approves it. The system signals you, who then approves the purchase, and a purchase order is generated. Is that correct?
That's correct.
Okay.
It's reviewed, and then it goes to Mr. Dubs.
So if the purchase order is over $10,000, Dubs receives a request to approve the item. Is that correct?
And any purchase order I deemed that I wouldn't, what happened, it sat out in his bucket, and he would never look at it. But the 10,000 I'd never touch, made a rule, and if it was one, like one to my daughter for the ACT testing, I would not sign, he would have to sign off on that. And I would tell him, look, they're sitting out there, you need to look at these, if they're any. Technology, obviously he would, because that would mostly be, we would have a plan of keeping technology up, whether it's ViewSonic boards, or we were more than one-to-one computer-wise, and laptops, and little, what are they called? I forgot. But there, the history would show, and the only ones that ever rejected were where they may have rejected a requisition at the building level. Or say, hey, reject this, because we want to change vendors.
So for your daughter, say if she needed something, would she, if a purchase requisition would normally go to the building secretary?
Absolutely it is.
She would go to the secretary first, she wouldn't come to you?
Correct. Yeah.
So you try to remove yourself from the process?
Absolutely. The only one, like I said, was, I don't remember if she went to the building on the ACT. There was discussion with Mr. Dubs and the unbelievable unleashing of 700 and some students to take the ACT exam in Waynesville during COVID. And that's where she did get a check. And Dubs approved the purchase order. It was discussed with him fully.
Did he do the purchase requisition?
He did. He was incapable of doing that, so I probably had to do it. I mean, incapable, we never wanted to learn it. I don't know. I don't think Jan would have been, but it would have been me, which, again, it appears totally inappropriate. I can draw judgment on it, but I'm telling you what happened.
Because you want to remove yourself from the
Absolutely,
process.
I
So
did.
why didn't you go to a building secretary or somebody and have them put the purchase requisition in?
I have no expediency. I have no excuse for that. Put it this way, they would have done it. I mean, if I did, it would have been fait accompli. We went probably to Sharon Vogel in high school because she'd have been most familiar with it. She'd have done it in a heartbeat. That wouldn't have been an issue. And maybe she did. I don't know. I honest to God don't know if that's what we did at the time. I don't remember. It wasn't anything under veiled. That was one that's really using money that's not really from the school. Just from the ACT organization. And the same thing would have been, Karen Phillips was the previous one, and could have happened for her, or There's another teacher that did it years ago.
So-
Charnel, Bees.
I don't think Charnel, I think it was,
I think of another
I
name.
don't know, Charnel's a good, I mean, she was a worker she worked at them.
So did the ACT, prior to your daughter being a coordinator, did the ACT always send a check to the district?
I think maybe over a decade ago they did to help pay one of our coordinators. The ACT typically has about, at Waynesville, I'm gonna say 150 kids take it. This is during COVID and it was closed. It was closed down all over the country. And I don't know if she shared with you, but we had, we talked to ACT and we're debating whether we were gonna have it. Dubs wanted to have it because we had kids. He was good about, you don't have to drive, and he was supportive. And we were worried about, I was worried about the protocol in Warren County. You have to wear a mask during the test. What does Mr. Dubs want in our buildings? How do we protect kids? And how do we protect whoever's gonna work it? And I actually did get involved in terms of calling the ACT and saying, I don't know. They go, well, we really need sites because they're closing down all over. Little did we know, I don't know, it's 500, 700. I had a bullhorn. My daughter worked her ass off of. We had the whole middle school in every classroom, gym, a list broken down by this door, that door, and I'm out there directing. It was crazy. Even had a police officer up to help. They were from New York City, New Orleans, Chicago, all over Ohio. In that case, prior to that, we said, look, we're not going to do that. I mean, that's crazy. And that's when the check was sent to Waynesville.
What was that check intended for?
It was intended entirely for her time as the ACT coordinator.
So
In addition,
they told you that?
no, we told them that. We told them what it was for. They don't.
What they pay her directly?
Yes, they did. About $400, I think it was, or I can't remember what the dollar amount is, but that pales in comparison.
So why couldn't they have paid her directly?
Oh, I wish, and
Did they give you a reason why they couldn't pay the extra check directly?
the only thing I remember is they had a maximum of what they paid. Whether that's right or not, I don't know. That's my recollection of it. And so then I said, well, then why can't we do this? And
Do you have any email communication with Mr. Doves or?
well, given it, I never dreamed 2020, I don't have access. So the answer to that is no.
No.
But there was conversation. He was in my office.
So when you said we told ACT what we were doing with that money, who's we?
Me and Pat Doves.
Were you on the phone with
I was on the
ACT
phone with the
yourself?
ACT, and Mr. Rose was sitting right across the office. Now, this goes back to COVID year,
Yeah, because the checks had just started right when COVID.
yeah,
There were no checks prior to that issue.
absolutely there wasn't.
And you were gonna pay Janae that extra money.
Absolutely, that was known.
And
And to tell you, what's funny about that, the hours spent on her, and she was up there, I remember, I think it was 1 o'clock or 1:30 in the morning, the SRO officer. I'd called because I had to go help her get into, try to help her move boxes, because she couldn't get the door to where they could get in. And I called the Waynesville Police and said, look, I'm gonna be up there. Sorry, SRO officer, hey, I'll stop up and see you. So he also had keys and was able to get her in a door we couldn't get open. So, I mean, it was probably 1 o'clock in the morning, I don't know, but it was crazy.
so I've got some direct questions regarding the ACT, and I think
Go
you
ahead.
do as well. So you're aware that she was paid directly by ACT?
Absolutely.
We already talked about that. For how long has she been doing this as the testing coordinator?
Well, Karen Phillips did it last. She's probably been doing it, man, I don't know, not 2017, I don't know.
Okay.
Yeah, 2000. Karen Phillips asked her to do it because Janae always helped her do it, and she took over.
And we talked to Karen, I think she said that she helped kind of recruit Janae because she
She
thought
did.
she'd be
And she did.
good to do that. Okay.
And I can tell you from my heart, there was no plan to skirt anything, and I think you're suggesting of forcing them to pay directly. It was weird. We were one of the low-cost centers, but I don't remember saying, why can't you pay more? It was like a standard amount we billed.
So we talked to ACT, okay, and we got their definitions of what everyone's jobs are. So there's a testing coordinator, there's a room supervisor, there's a whatever, there's custodial,
Guardian.
there's a security. So one thing we did find is that many of the things, and I'll just kind of go through here. So,
And the janitors were paid by ACT.
correct, that one of the jobs, and you mentioned in your emails, that she had to tape over walls and hide materials that they could help take a
Which
test.
you wouldn't have done in the past because we didn't use them in any classrooms.
But that is part of, in talking with ACT, that is like one of those jobs that's expected. That is part of that position's duties.
Not the volume that they would have
Hold
expected.
on. And they are also, that test coordinator is also reimbursed based on the number of students taking the test. The number, like you said, you're
Did
not
not
sure
know
how
that.
it was figured out.
Did not know that.
But that's how it's figured out. So she would have much less of a check from ACT
If it was
directly
lower.
if it was a lower number of students that were
Don't
taking the
remember
test.
that.
And that would make
We-
sense in previous years if she wasn't
We
making that
called
much
them,
money.
when we first called them, it wasn't more about pay at the time because we didn't know the number. It was more about COVID protocol.
Now, again, so we asked about the COVID, we asked about, they said, well, that's why, that's what the custodial fees were. So I interviewed all of the custodians as well, and I asked them, what jobs did you perform? Did you work these ACT Saturdays, did you know, or whatever, I think it was mostly Saturdays.
It's always-
What was your job, what did you do? And that's what they explained. They were responsible for the extra cleaning of the desks, trash pickup. They had, not only was there normal, like if there's a, well, and I asked that question, did you see Janae doing this? The things that they saw Janae doing was taping up
She
the,
cleaned
the,
Then she had to rearrange.
the walls
they
and
did
things like
had to
that.
Rearrange chairs.
So I'm just telling you, like, you know, we've done some homework and we've looked to see where that was. We did have questions ourselves to ACT. We wanted to, you know, nail down, okay, well, whose job is this to this, and this? What would be a custodial fee that you would reimburse a school for? And the way that came back, and in talking with Mr. Dubs as well, was related to, what's my word? No, it was normal.
They paid the custodians directly.
Correct. We're asking basically what was this extra check for? And they said it was basically a site fee and cleaning supplies.
Thank you.
I don't remember
For the-
cleaning supplies.
And it would also go towards utilities, et cetera.
Okay.
But that's
No,
what that
that-
custodial fee is meant to pay for.
Okay,
Okay? So, looking at it from our point of view,
it looks bad. That's fine.
okay, and you understand that.
I do.
So that's why.
And I don't even remember what the
we-
fee was.
That's why we had to look at this. So,
$350 check each time, pretty much.
2 times?
No.
She got, altogether they issued 11 checks and she got 9 of those.
so Janae actually made
Oh, it's because they were,
over 4,500 directly from ACT.
they were going through, we had dug on ACTs more than anybody. You're right. It wasn't 3 times a year. It was probably every other month. Go ahead.
So she directly had from ACT was 4586. But from Wayne Local, that extra additional check, she was given $3,150. So of the $4,000,
She
$4,050.
just didn't get like the last 2 in July and June of 22.
I think the numbers dropped. But I would say this, she is not anywhere near a business person to come up with trying to do something bad.
And she wouldn't interview, and that's.
Well, let me explain.
And I
And she
understand.
talked to me. She had done testing all day, that day.
Yeah, that was for the
No-
kindergarten.
Kindergarten
preschool,
assessment.
Right.
There was no notice. Now, let me tell you what my home life's like. And I'm going down a dark hole as we speak because I love my children. I know she would never have intent to defraud the school because ACT pays the school and the school pays her, and that seems like that's okay. Obviously, that was stupid compared to you, but it isn't to me. But my life at home has been much like this. Me, what's wrong, Dad? I've had to hide from my daughters a lot of my thoughts. And when she hears about anything to do with fraud, investigate, whatever, if you had daughters that loved you and would kill for you, even if you were wrong or whatever, and they know I'm not, she's scared to death. You would intimidate her, she would cry, you could beat the living hell out of her, and she would she would just clam up because of the stress. The stress on her, probably through me not being able to cope, has impacted her ability to talk to anybody.
And I didn't hold that against her.
Yeah.
I'm just letting you know that
No.
some of these questions
But when
we
you
would
say
have
that an
asked her.
opportunity, yeah, I agree. If, again, if there was a list, she asked for you if she could get a list of the questions ahead of time. So she could prep and you wouldn't do that.
Right.
Or you never responded. So,
In all fairness, we don't do that with anybody.
Right.
no, I'm not
It's not
judging.
just
Please
her.
don't take, I'm just giving you a different
Right, that's okay.
perspective.
Right.
We get asked that all the time.
And, well, I mean, if I know what's coming, I'd kind of put the pieces of the puzzle together and know, holy crap, this is a lot bigger issue. Not fraud. I don't have any doubt about that. But there was no. I
But
guarantee on her
you
part.
understand the
And
conflict.
her, I agree. But in her, and just from her perspective, I was doing an unbelievable job, and I did all these hours, and we had a creative way, which we talked with the ACT of how we could do it. Now they could have said, well. I'm not going to blame ACT. It is what it is. School, ACT-based school, and then the agreement with Dubs that Janae would get, that check back.
And if you find any communications to prove
That's
that you
impossible.
had that,
They've blocked. I have no emails. I didn't keep all my emails.
would that have been a verbal conversation or would that have been a written conversation?
That would have been a verbal conversation. I don't think there was an email. Hey, I do think though. Let me be clear. He signed off on the purchase order, and I
Did
do
he
think
physically sign off? Because in the system, we went back and looked and we don't see him accessing the system.
he had to have signed off on that. I would not have done that. I would not have approved Janae's. I would not have done that.
Because you just know it's wrong or you don't have that capability, I guess?
Say that again.
Because you don't have that capability to do it in the system or just because you know it's
No,
wrong?
because I would have wanted him to follow up, and I do think there was an email. Because Becca was supposed to put the email or that proof that he confirmed in each one of those, in with that purchase order and check. Now, if that's not there, then she didn't do her job.
I have the purchase orders and
Do you have the check too?
I have all the checks and the purchase.
Do you have anything with it though?
What do you mean? I have.
Did you,
full
but you
system
can,
history.
but you can print that out. I'm talking about the actual, we take the check and attach it to the invoice and file it. Yeah, that's a check, but there.
What are you saying?
How did you get that?
How did I get
Out
that?
of the system?
That's out of the system, but these are from the bank statements.
No, okay, I'm
So
not.
I guess I'm not
I give
understanding
up.
what you're asking, saying the actual check.
What's the other,
There's a copy of that,
Uh-huh.
okay? And you attach to it what? The invoice or any document to prove what you did. So that check would be stapled to an invoice.
Yeah, we don't,
You don't have that, that's why
we'll ask them for it.
yeah. To go back and look.
So you're saying on the invoice it'll say something?
It wouldn't have been an invoice, it would have been the email that Dubs to prove that. And I know that those, I'm not stupid not to.
Because I have where you put it on the purchase requisition that he approved it. Because you're the one that filled out the purchase requisition.
Absolutely I did.
So you put it on the purchase requisition, which would then go to the purchase order.
Well, then,
And
Yeah, I
that's
guess-
your history of,
I'm saying that there should have been hopefully a document that said that there was a copy of the email to him. But
so you're saying there should be an email, not,
no, that I put on there in response to the fact that I'd contacted Mr. Dubs, which leads me to believe there should be an email.
and this is later on, the earlier ones don't say approved by Pat Doves. They actually, I don't think say anything. Or they say just ACT coordinator, they don't say approved by Pat Doves.
I understand.
So you understand the conflict of interest law? I don't know if we're interested in a contract where you're supposed to basically excuse yourself from any supervision of your daughter or basically signing off on.
No, I did not know that.
Because every requisition, we've gotten all of, you've done all the requisitions.
For this,
Yes, for
I agree with
ACT,
that.
yes.
and I'll say it
So you'll
wasn't,
see ACT supplies and cleanup. That's, we put that on the requisition there. So that the one didn't say Pat Doves. There's a lot that don't say Pat Doves.
well, then I'm guilty, but I'm not nefarious and I didn't do that intentionally.
Okay.
It wasn't, it is what it is. From your perspective, it's horrible. From my perspective, I guess it's also horrible, but I didn't, it wasn't my heart. And I'll say this, I don't have anything to say.
Well, you're saying that Pat, because we went into the system history.
Did
report.
Pat say that he'd had any discussions about helping her in any way, or did he deny it?
We asked him, I believe. I'll let Diane just,
The-
if he wants to, she wants to.
The only direct relation was what that money was for. And that money was not, he did not authorize that money to go to Janae. That money was authorized for, that was for the
Let me
school.
be clear. He wouldn't even, he's not capable of making that statement because he wouldn't know that piece. He would have known when we talked with them what it was. He didn't have any, I don't want to say it, nuclear physics questions cannot be answered by somebody that majored in English.
It wasn't in his world.
Oh, no. But I see in your world. I see in your world. I don't.
Let me ask you this, your email was shut off, I know you can't access it. If we went in there and looked in the email, would you see the email communication between you and Doug's, maybe that we'd be able to?
937-789-08.
I think I might have that, it may have that too.
I have no idea, but I guess based upon, the information before us, I don't see any reason that I can refute what you've already come to a conclusion. So I know what's in my heart, but that doesn't sell. If you had an email,
Even if you had an email, you should still be separating yourself.
well, once you tell me that, but I honest to God, that didn't even enter my mind. It wasn't, man, I'm gonna take care of my daughter. This would have been Karen Phillips. Would have.
Well, why wouldn't she have went to somebody else, I guess, to do the requisition? Why did you?
My daughter, remember we talked about being in the world? She wouldn't even understand.
Did she know she was gonna get this payment?
Oh, yeah, because it was discussed prior, again, you need to dumb down the level of my daughter for a minute, that she doesn't work in the realm of finance. She works in the realm of, I'm gonna do this ACT, I'm gonna put in these ridiculous number of hours, how am I gonna, how I'm only.
What's in
gonna
it for me?
Yeah, what's in it for me? But not to the extent of, to hurt the school. I mean, my God, the effort she put in was incredible during those times. And if we didn't handle it right, well, then that's all on me.
Did any of the other teachers and stuff do anything extra, I
No.
guess? Why would they not be entitled? If she's entitled to the whole 350, why are they not entitled to
Oh,
anything
my God.
else?
I mean,
If she do
you have
that
no,
much
you have,
more,
you
I
have
don't
no,
know.
oh, my God. What they do is they come in, they sit in a classroom, watch the test being taken, and they leave. She's responsible for all the distribution, getting all the materials ready, getting all the materials back, accounting for them. That is,
But she's paid more by ACT to do that, right?
de minimis. It'd be better for her not.
But ACT just sets.
Look, I'm not gonna argue with you.
Yeah.
If you think I'm guilty,
No.
there's no reason.
We don't I think we
It's not
probably
even
agree on the
close.
fact that, I think we probably agree that the reimbursement for that type of a job should be more.
And it was my
think that's a-
understanding when I talked to ACT, it wasn't, there was a maximum for Wayne local schools. I wasn't aware there's a per person. And my daughter never had, she never called up and negotiated some deal with them.
Yeah,
Look,
ACT, I think.
she's a kindergarten teacher.
Yeah, they set the.
In a first grade, kindergarten preschool, that has no business sense at all. Not one evil bone in her body. This would be all on me, not bad, I never even thought of it as a contract between, I'm thinking of it as ACT and she's doing the services, and it's between ACT and the people that work. And it was ridiculously low amount of money for the time spent. And when I talked with the guy, they didn't see a big deal. I said, well, here's an option. They never once said to me
Who
about
did you talk to?
ACT.
I do know the name.
Hell,
So we could contact that person and see what they.
I have no idea. I know he lived in Texas. That's been years ago. No.
Okay.
Look, write me off. It is what it is. But I can guarantee you she had no role in that. And I had no plan to to aggrandize my family. I paid out of my pocket to her if that was the case. But this just seemed like, and I did have that discussion with Mr. Dubs, and he's a goddamn liar if he says it was, he wouldn't even know supplies. He would have thought, well, why don't we just pay the janitors out of the general fund and then reimburse them that way? And that would have been stupid because you got all that mark on, so that, it is what it is. And looking
Well, there's
from your
no need to
perspective,
because ACT will
we'll
pay
pay
the
it directly,
janitors.
yeah. Wasn't intent. But what I don't like is that Al Porter, well, shut up. I just made this.
Is this related to the ACT or?
Yes,
something?
yeah, but I'm gonna shut up. It
No.
is. I've been hung and
But
by the jury.
we're still here. So, like I mentioned, I saw that you were reimbursed by ACT as
And that is
well
absolutely legit.
as a, I think
Probably
it's a
security.
security position.
Oh, my God.
You mentioned the bullhorn, and when I asked different people, they said, yeah, he was out there with a bullhorn, saw him there. So, that's not
Went and got
questioned.
teachers breakfast,
Just curious, just to confirm that you had actually been there yourself, so you could.
walked the
You
halls,
could talk, okay,
Yeah.
talk to this.
had fun with the
So-
teachers over there.
Does about $1,200 sound about right
That was
Total.
been several.
over
Yeah, probably.
a few,
I think you got, was it like $200 check
Yeah,
each time or
something like that?
Yeah, it was the bullhorn man, or
Okay.
helping get tape up where they go, and it was getting kids lined up with their credentials, to get them signed in to the school.
Yeah, you got,
I
show
was-
the ID.
Yeah, I had them all ready.
Right.
If they didn't have a calculator, I'd go get one of mine.
We're gonna jump to another issue, and
Stopping at 2 hour, 30 minute, 35 at that point.
Mr. Harper, we need to take a break.
Okay.
May I, Your Honor?
Yeah.
Very quickly, I just want to put on the record, when the investigator makes statements about what ACT told her, those are hearsay. They are not to be considered as substantive evidence, especially when they contradict the evidence that's been introduced in court.
The court is very well aware of the evidence that has been submitted from ACT directly. So I'm going by what that person said, the information that the court has. I'm aware of the rules of evidence, so thank you for that.
Well, Your Honor, I thought maybe another court may look at this someday. You never know.
Okay, so let's take a
Thank
10 minute,
you.
let's take a 10-minute recess.
Ms. Ware?
I'm gonna receive these from the fire attorney, I'm letting your research, from the
Okay, let's see here.
What kind of attorney do you expect me to have to support your attorney will take care of something?
Well, I think that's all we have for now, so I know we'll have other things in a minute.
Okay. We can start with 8 earnings for the value of this one. And what's the other thing? Have a seat. Page 9, let's know what the regulation does also regulation the time for.
Yes, ma'am.
We have a voting.
Yes, ma'am.
Page 9, what's on it?
I'm Gonzalez. Monica, thank you. Oh, we have a plea coming up, right? Okay. Okay.
Thank you. If everyone's checked in and tried the commercial one, only been on. Another one. Oh, no. Page 13. Johnson. We got another
Yes.
one.
Yes, ma'am.
Page 13. Johnson. Yeah.
Oh, Nadia Johnson. Okay, got it. Thank you.
One is you wrote when this. Ready, please. As long as how are you doing today, Joe?
I'm good. How are you?
I'm all right.
Well, that's good.
A little rough day yesterday and getting back to the swing of things.
Yeah, I know when you're gone for a week, things kind of pile up, right? Oh, I know. I know how it is.
I haven't taken that long of a vacation in a while,
Really?
but you're gonna pay for it, you know.
It's okay, but you need to get away
Mhm.
for a while. I mean, you can't just not have a little bit of time off. Okay, give me
was
1
great.
second.
I don't regret it.
No, good. All right, this is Mr. Brady, right? And we're doing all 3 of his cases. All right, give me 1 second and wait till it pulls up. And I believe I had mentioned to you, Ms. Sims, that we're going to give him credit for the most time that he did on all 3 of his cases. Give me 1 second. Okay. So we got 38 days credit, right, Nancy? Okay. All right, so you are Jaron Brady. Mr. Brady, you are charged with 3 offenses of harassment. These are 3 offenses of harassment that occurred on 3 different occasions. So you signed some documents this morning in reference to all 3 of your cases. One of the documents that you signed is entitled Misdemeanor Plea of Guilty. So you signed that document on all 3 of your cases. That document, sir, says that you have certain constitutional rights. That document says that you have a right to have a jury trial, a right to confront any witnesses that may testify against you at that trial, and a right for your attorney to cross-examine those witnesses. However, when you sign that document, sir, you give up all of those rights. Do you understand? Now, Mr. Brady, I do have to advise you that under federal law, if you're not a U.S. citizen, a plea of guilty could result in your deportation, denial of naturalization, or admissions to this country. You also signed 2 other sets of documents on all 3 of your cases. One of those documents says that after today, you do not have a right to appeal your case. Your case ends today. And the other document that you sign on all three of your cases says after today, there's not going to be any more work or investigations done by your attorney or the attorneys for the state. Your cases all end today. Do you understand, sir?
Yes.
Now, Mr. Brady, did you sign all of these documents freely and voluntarily? Has anyone forced you to sign any of these documents? And has your attorney, Ms. Sims, answered all of your questions that you have regarding all 3 of your cases? Mr. Brady, to the offense of harassment on all 3 of your cases, how do you plead to harassment on all 3 of your cases? Guilty or not guilty? Are you pleading guilty because you are? Mr. Brady, on your plea guilty, the court finds you guilty of harassment on all 3 of your harassment cases. So you're going to be convicted of 3 harassment cases. And assesses your punishment at 150 days in the county jail. You will be given credit for 38 days that you served. So you'll be given 150 days on all 3 of your cases. The court is going to run all 3 cases concurrent, which means that whatever time you do on one, you do on all 3. 150 days in the county jail means that you still owe the county some time in jail. You still owe the county approximately 12 more days. So you'll be here approximately 12 more days. As soon as you complete 12 more days, you should have completed all of your sentence, and you will probably be released in about 12 days. Any court costs that you might owe on any of these cases, sir, I'm going to run it concurrent with your time, which means that you will not have to pay any money whatsoever on any of these cases. All right, Mr. Brady, do you have any questions on anything that I mentioned to you, sir?
Sir.
Ms. Sims, any questions?
No, Your Honor.
Mr. Brady, good luck to you, sir. Thank you. Thank you.
Miss Sims? I'm sorry. I'll go on here. Good morning, how are you? I'm good. I'm impressed. Still,
Harbin, I apologize, you may continue.
Before we look at the next portion of your interview, I want to talk, in that portion, there was conversation, Mr. James indicated that there might be some emails to Mr. Dubs, is that correct?
Well, actually, my perception of that conversation was that most of that would have been through phone calls or just verbal conversations. So he,
Objection, move to strike. The tape has been played and it speaks for itself. It's not for first of all, she's not being responsive. And second of all, it's not for her to contradict what was just played or interpret it.
I'm gonna overrule it at this point.
You were saying you want to continue?
just that I didn't believe necessarily that there might be a written documentation of this.
Objection and move to strike.
Overruled.
Ultimately, were you able to see that there were some emails that were exchanged between Mr. Dubs, or actually from Mr. James to Mr. Dubs as it relates to at least one, if not two of these ACT checks?
Yes, much later.
One of those being what's been marked as State's Exhibit 13, which I think we've previously discussed here in court. But if you would, if you grab that, and what is the date of that particular email?
October 29th, 2020.
And if I could, I want to direct your attention to State's Exhibit 1H. I'm sorry, not 1H, State's Exhibit 1F. Can you go ahead and look at State's Exhibit 1F?
Got it.
What is that?
That is the check written on Wayne Local School District, Lebanon Citizens Bank account, paid to the order of Jana James, $350.
And does that relate to ACT?
It does. It's dated August 28th of 2020.
Thank you. You could, obviously, you told us this interview was 4 hours long, so I want to direct our attention at this point to the 2-hour, 35-minute and 15-second mark to 2:41:30. During this subsequent conversation with Mr. James, was there conversation about Grandma's Gardens and his relationship to them?
Yes.
I'd like to go ahead and play that portion of the interview at this time.
Grant, and they bring it up in a board meeting, and I explain in front of the entire board that A, number one, you asking is a conflict of interest, you cannot do it, you have to resign from the board. Number two, we're not eligible for the grant because we already have a wellness program. You could not get the grant if you already had a wellness program.
Gotcha.
That would come up, well, he won't even get the wellness grant. You won't, I guess get exasperated. Another time that I would have informed the board is probably Brad Connor was president, when he called and said he wasn't paid for cleaning the bleachers. I said, what are you talking about?
Yeah, you
The
mentioned that in your
Boy
email,
Scouts
too.
do. And he said, no, I did it. The Boy Scouts didn't show up. My son and I did, and I want paid. I said, I can't pay you or your son. That would be.
Wasn't he a scout
Leader.
person? Leader, okay.
I said, we can pay the scouts for it, and if you work with them. And so that was another one, and I would have brought that to attention of probably Brad Connor was the president at the time. And Dan McLeod.
So tell me why being paid $2,000 a month for 15 years by a business in which you introduced a contract before the board isn't a conflict of interest?
Okay, let's make something very clear. You just answered your question. I went before the board and said I have a conflict of interest. That's why you have to approve this. You must approve it because I will not. I said it openly.
So not telling them that they needed to approve it, but that you needed to remove yourself from that.
And that I get paid by him. I said he is here to present, the board.
So they were aware that you do get paid by him?
I informed them in public in front of everybody.
Okay.
It's in the board minutes that the board, I said, you have to approve this. And, or don't approve it. I didn't say you have to. That's,
Right.
you can.
I understand,
So
yeah.
absolutely, there have been a.
But you disclosed it.
Oh, I disclosed it and they approved. And that's where Al Porter told people and yelled at Doug, there was a conflict of interest and, that I should be whatever, I don't know what he said. And that's ridiculous. I didn't even want Doug to do it. What happened was the Performing Arts Center had number one, the elementary, that piece that was paid ridiculously, the people went bankrupt. So they did this architectural design, it was a firm, and we probably lost 40,000 of cash out of that deal. Then we go over to the Performing Arts Center, and they were down to, in limited funds, and wanted somebody to do the architectural. Clear as mud, Dubs turns to me and says, well, you can get your Bud Doug to do it. I said, no, he's gonna have to come in and do a presentation. He came in, I still have the book.
So you're saying Dubs is the person who mentioned that,
He would have mentioned in a meeting that, why don't I get
or suggested, why don't you
suggested.
get?
And there was
okay.
no force by Mr. Dubs. Mr. Dubs
It
is
was
innocent.
just like a
Because-
brainstorming, why don't you?
Can I tell you why? Because whenever, like before Memorial Day would come, if the place looked like crap, Dubs would say, I need to have Doug. I said, well, you're gonna have to have him come in. I'm not part of it. You know, there is no conflict there.
I mean, if it's in the minutes, you disclose.
It's in the minutes.
Okay. I don't know, I haven't looked at those
No,
minutes.
it's definitely in the minutes.
I didn't see that specific statement in the minutes. Are they audio taped or videotaped?
No. We had one of the board members be performing to the tape, and they wouldn't. We taped them years ago, and they asked me to stop. But no, it's in the board minutes where the board approved Grandma's Gardens. That is a known.
Right, I saw that.
Without a doubt, that is
Okay.
a known. That he said he didn't see that.
I didn't read the minutes.
Oh, yeah, no, I saw that it was approved, but I was asking if,
The disclosure was in the minutes.
if the disclosure was, you stated
oh, it
that
was-
someone had asked you to see if Reinhardt would help by presenting a landscaping plan, and you're saying Dubs is the one who is
I
that
don't want to blame
person?
it on Dubs. Dubs would
Well, it's not a
know.
blame, I'm just saying like, who, do you remember who brought it up to you to say, hey, why don't you have Reinhardt give you a plan? Come
I
up with
don't,
a-
I don't remember if it was Dubs. It could have been Broomball, the construction people. You could be sitting in a meeting, they could have said, do we have anybody local?
Was Dubs even there at that point?
Yes.
Because Dubs left in June, right?
No, he was there.
When did he leave?
He was there. He didn't leave till August 1st.
Okay,
He was in the board meeting when the presentation was made.
okay. So you're not really sure, but someone.
But I mean,
within-
Broomball said who in the areas, Grandma's Gardens is one of the elite landscapers. I mean, for them to do a $400,000 job is the owner of the Speedway. It's ridiculous. I can't even relate to the amount of money people spend. So no, there was absolutely no, so you asked, where was there a conflict? Absolutely. Did I disclose it to the board in a public meeting? Absolutely. And did I ask the board to vote on it? How many vendors did I get approved in a board meeting on any other purchase? Didn't have to, none.
Only if they would have met the bidding requirement.
Correct, exactly right. And so this one was, I don't remember, 24,000. I think we're allowed to spend 50, I was allowed to spend 50, but I'd have never done it. If it had been $10, would not have done it. Would have done it.
Wouldn't have done it.
I would not have let him do it. I wouldn't even, he would have had to go before the board. If it had been for $1.
Oh, I see what you're saying.
If it had been for $1. But if you see the work and the price, it's ridiculous savings. And, no, please, not any.
Just a couple touches and then another issue. So in your email, you said that you had no influence over hiring or firing.
It's 241.29 is where we stop. I want to go to the 250.58 mark. Does the conversation with him again turn toward ACT and Janae and those particular payments again throughout the interview?
Yes.
Ask you a question. How much was Janae's amount?
For ACT,
Yeah, that went through the school.
3,150.
I want to say this, and I apologize. It is honestly, I think, the amount that she should have got. But, and I'm not trying to get out of jail here, but I'll write out a check tonight for $3,150 to pay back to the state of Ohio. That was obviously not well documented if you don't have a copy, And it wasn't, I would swear to you, I don't feel I'm guilty, but I don't want the bullshit tied with that, you know, and it's legitimate on your side. I see with a cynical eye what it is, but I know she wasn't a part of it. It was, oh, no, she was in terms of did this is much money and talking with them, and we'll talk with Dubs. But if it would have been any teacher, honest to God, I would have probably done the same thing. I would have done the same thing, and I'd be paying it back. So am I allowed to write that check out?
To a purchase order?
No, am I allowed to pay you back?
Pay the $3,050.
Oh, well, that would be,
You wouldn't pay it to us.
you will pay it to us,
I mean, who
right?
do I pay it to?
That would be,
Can I give you the check?
I can't tell you what.
yeah, we can't tell you what
No,
to
no,
do.
I'm not saying.
If you felt that that was something you wanted to do.
No, my point
then
is-
we would include that in our report to say that you felt that,
In review of it?
in reviewing it, you felt that that was not an appropriate,
Well,
reimbursement
I hate to
or-
use those words.
or however you'd say it,
I would say
you know?
there's no, I did not feel there was any inappropriateness in it, but based upon how the viewing public would view it,
I would recommend, I know you
I would recommend.
talk to your legal. and
Yes.
how- I know you don't want to discuss, but I
Correct.
would let them tell you how to handle that.
well, no, I guess I'm beyond that, because it'll cost me $400 an hour.
And I know you said that, but we can't give
No,
you that
no,
kind of
I'm not-
advice.
I don't want advice from you.
Yeah,
You're
okay.
missing what I'm asking you.
Well, I don't know
And
that we are, but go
No,
ahead.
you might be just by a smidgen. What I'm saying is, if I pay the $3,150 to the district, or to whoever, I prefer to give it to you, made out the way of the schools, as reimbursement for that reimbursement without, what I want to do is not, I don't want to have her go through the mud, and I don't want me to face it because it's going to make me look guilty. So it's not a get out of jail card. I just want to stop before you even have to worry about a finding recovery, because I've repented of my sins and paid it.
Right, I get you.
Am I allowed to do that?
I got you.
It's not giving me advice to do it.
Right.
It's am I allowed to do it?
Well,
at
I'll
this
tell you,
stage?
if it did go to finding for recovery, if you did that, it would still be reported as a finding for recovery, we paid under audit. So it'd still get reported no matter what, if that's what you're asking, if it would stop being.
Oh, and maybe that's,
It's still gonna get.
But it would
reported.
show that, like you're saying.
So if, I don't know if that answers your question, but.
Move on to.
so, but,
Go ahead.
and I have your address. Yeah, I understand. I'm not, I guess that's fair. And by the way, I'm not a rich person, even though you've been in my bank accounts.
Do you think, yeah, we're state employees, so I mean, we got into the wrong field.
At least if I
I'm
did
just
it.
seeing what we haven't answered
Of
already.
all the ones that I see that, that are unacceptable to me, looking back on it, it's not that I believe it or not, it's just that it would be under the light of what we see, the right thing to do. Not, you're not forcing me, you're not, I don't necessarily believe that I did anything wrong, and I don't care if it's reported, but I paid it back. And I stepped up and did it proactively.
Well, I can tell you, none of that,
I
if you did
appreciate
decide to
that.
do that, the money wouldn't go to us.
No, I know that.
I
Right.
mean, you couldn't even deliver the check to us to give
Right.
to them.
So how would you even know that I did it?
Oh, they would have to report it to us.
So I just made it out to Wayne Local Schools?
And I would probably specify maybe what that was for.
Oh, absolutely.
Yeah. If you wanted to discuss this, that's really,
No, stop there, that's at 2:56. Toward the end of the interview, how would you describe Mr. James's demeanor as the interview kind of came to a conclusion?
sullen.
Did the way he was responding, statements he was making to you, give you any concerns, and if so, what were they?
Absolutely. He made some statements about harming himself. And I made sure that I spoke with his wife outside after, or in between, after that point in time, to make sure that maybe he's contacted a mental health professional, if that's, if they're aware of these issues. And she said, at that point, we had conversation about that. Yeah, so I did express to them, to family as well, to make sure that, you know, they understood that we were concerned for his safety as well.
I want to play two more excerpts that are toward the end. The next one being 3:36:45 to 3:38:06.
A certain period of time to live, and between that time and then you can end it on your own. That's my mentality. And I don't drink, I don't do drugs, I don't do any of that, but I'm in a spot that if I remove myself, one of my grandfather taught me, don't ever give the name James a bad name in the community in which you live. And I don't deserve this. Now the 3150, you can draw judgment on me, but if you'd have came to me, do a normal audit and said, why did you do this? I said, well, here's why. They just said it. I said, shit, could have been handled. I don't expect others to catch that. You would have, or somebody would have, because it's obvious. You should have looked at it. And I applaud you. It don't bother me a bit. Because I kept searching my mind. I've never written any checks out. I didn't even think ACT. I kept thinking, I don't do anything. I don't handle cash, I don't write checks. And I sure as hell don't tell people how to count damn lunch counts. But that one, this one, I can repent of stupidity and mistake and do it without, just like paying back the 10,000 that I got, that I thought was, that they all talked to the board and that wasn't a big deal and it wasn't out of the ground. I gave that money back, and never intend.
Well,
Finally, I want to look to 3 hour and 52 minutes to the end.
I realized I gave you my phone. It's probably the worst thing to do.
That's
Work it down there.
that's exactly what I thought.
And
You see,
you can contact us anytime.
Yeah. Do you have my number and you have my email?
I have put that in a special place. I have anxiety, to be able to tell my side. But out of all of it, never.
Well, I think you have though. I think.
It is what it is.
Yeah.
And this is what we have.
I know that.
Yep.
This is it.
There's no secrets.
And
Yep.
I know on the ACT with my daughter, and she can attest to it, my daughter doesn't have a evil bone in her body, and she's not savvy. I mean, I often kid her that teachers that teach in elementary have the mentality of the kids they teach. And she's preschool first grade, which is their kindergarten, which is.
Her mentality isn't bad.
No, but it is from a business.
She's a college educated.
No, but what I mean is that if she got paid for ACT, the school got reimbursed and the school paid her, she would not devise that plan to be evil.
No.
And we're not saying she did.
No.
Right.
No. And I did it for a fair wage, and I did it incorrectly. And I understand that. I don't mind it. If you'd asked me, let's say you didn't even look at it, and then we'll get out. If you would have asked me, if you would have asked me, Ron, did you ever have money go to your daughter via a purchase order in any event? And I would never have lied to you. I said, you know what? Through the ACT
John
testing.
Boyd, Nora,
I would disclose that.
7134.
I guess don't need the proof of it, and I would have actually loved to have done that ahead of time, but it's obvious. But you know, it didn't get discovered anywhere, and
Right. Well, thank you.
I'm sorry for
We,
the time you had to take.
no, you deserve that time to be able to explain it.
Case. You all take care.
All right.
Thank you, Ms. Boza. No further questions.
Mr. Smith?
Did you, say, yeah, no further questions.
Oh, sorry, I need to pay better attention. So Ms. Booza, so I understand the context of what we just listened to. This investigation started in February, roughly February of '22.
Correct.
We know, if we're looking at a timeline, and we're gonna come back to Grandma's Garden, but we know that this investigation started in February '22. Grandma's Gardens takes place in terms of Mr. Reinhardt and the board in the summer of '22 during your investigation. Yes? You have to say, answer it out loud.
The actual work gets done somewhere in the fall, I believe, of '22. Correct.
Okay, let me
So
correct
after
my
it was
statement,
started,
because we're
yes.
gonna be painfully accurate with each other, aren't we?
I just want to answer you.
He was
accurately.
contacted, did the design, did the bid, presented it at August 8th, and did the work immediately thereafter in August and early September of '22, correct?
That sounds correct.
Then, in October of '22, this gentleman retired, right?
Correct.
And so this interview you're doing is 1 year after he retired.
Correct.
He hadn't been in his office for a year.
As far as my knowledge.
Well,
correct.
you were there a lot. You see him?
I wasn't at that office after that.
Oh, you never did, you didn't do any work from there after that?
We had to go back and forth and pick up documents, and they were moving into the new office.
That's because they were in temporary places and the documents were spread all over the place, right?
According to them.
Because of the buildings and doing his work out of a ranch building that the school owned to expand on later, that kind of thing, right?
Correct.
So, the interview that we're just listening to is a year after he's gone. Presumably, you know he's not in his office and he doesn't have access to what the records, the emails, the electronics of his office, right?
Correct.
Okay. And you're talking to him about events that happened 3 years prior to the date of your interview.
Correct.
That's the background for your discussions with him about the ACT.
Correct.
He tells you in this interview that he thought he talked to ACT. Remember that?
Correct.
You actually were, I shouldn't have objected before, because you were going to say, yeah, your impression was he talked to them, right?
Based on that.
And there's a
answer.
mention of an email even in the interview.
Potentially. Correct.
Well, potentially, you're here today, you know there
I
is one.
found there is. Correct.
Yeah, but you see, you're the one, you and, is Mr. Batchelder?
Correct.
You're the guys that have access to all these documents and emails, you just didn't go look for them, right? When I say all of them, I mean his emails with ACT. You didn't go look for them.
We had asked the school previously for some documentation.
Really?
We
Are
did
you
not
telling the
subpoena.
court under oath today you didn't have access to his emails? I want to know.
I did not have access to
You
his
did
emails.
not?
I did not have access to his emails, to
Really?
that system.
You did a report of investigative activity, this big thick thing I'm holding up.
Correct.
May I approach the witness, Your Honor?
Yes.
I'm on page 826 of the discovery.
Okay.
I want to show you an entry you made in your own document of 9/19/22. Sorry about that. See it?
Yes,
Buyer's call. That's the guy who testified yesterday that has the grudge.
Jackson.
That's the guy who testified yesterday.
that is.
Buyers called, individuals that have not been contacted, still willing to talk. He has worked with IT and now can access his emails from years ago. Sent 19 of Treasurer James' emails containing financial reports for last 3 years.
Correct.
So let's try that again. Did you have access to his emails?
I had access to the emails that were forwarded to me by Mr. Byers.
So what
But
you're
not
saying
for the
is you were
school.
letting Mr. Buck.
What's your objection?
Can she finish her answer?
Let's have one person talk at a time, okay? All right. Did you want to complete your answer?
I did.
All right.
I had emails forwarded from Mr. Byers and other board members because I had asked for specific support.
So, I think now we know that Mr. Byers is aiding you in your investigation, right?
I think they were all very cooperative in the investigation.
That's not what I asked you.
Objection.
Overruled.
He's aiding you. He's feeding you, isn't he?
I think he was providing information.
And you were relying on what he decided to give you, not your own investigation, right?
That's not correct.
Well, maybe we should read this again. He has worked with IT and he now can access his emails, meaning Mr. James, right?
Jackson asked the answer.
Overruled.
I was asking Mr. Byers and the board members for emails that would support that Mr. James forwarded financial documents related to board meetings. And
Look,
that's
but-
what they were forwarding to me.
I understand.
Just to support what Mr. James had
So
told me.
show me
That
in
he
this-
provided documentation from the board,
Well,
for the board.
So what you're telling the judge is that you ask Byers for what you want and he goes and gets it for you, right?
I asked each of the board members to provide support for what Mr. James had said he had provided to the board. So I was investigating the information Mr. James provided to say he provided documentation to the board members in which it appeared he did so. And we were in reference to Google Docs and items, financial documents that he was supposed to disclose to the board at board meetings. So it's things he's supposed to provide to the board. And the part of the complaint was that he was not providing proper documentation. So I was hearing out the witness, as you mentioned, that he had a complaint related to not being told enough information, financial information. So in finding the documents that even Mr. James supported, in his own forwarding of Google Docs, et cetera, all financial documents, it all supported what Mr. James had stated, was that he did properly send information to the board members prior to board meetings.
Point of my question is, you know how to get his emails, right? He just asked Mr. Byers to go get them.
I did not ask him for other emails.
Well, that's my point.
No.
I've got this 30-page investigative summary. I can't find anywhere where you ask anybody to find Mr. James' emails relating to ACT. Because it's not in here, is it?
No,
And you didn't do it before you had a 4-hour interview of him under the circumstances we just indicated, which is asking him about things that happened 3 years prior and he's been out of his office for a year. Right?
correct.
And what more, you actually asked him for that documentation in this interview. and he hasn't worked there for a year, right? It's like, well, can you produce this? And the fact is, you have the power to produce it, not him, right?
Objection, there's like, what's the question? I don't.
He's asking if she agrees with what he said, was the question.
Can you restate the question?
I'm sorry?
I'm not sure what you're asking exactly.
You don't know what I'm asking?
You asked many things there.
You take this man for 4 hours in an interview at a police department a year after he's out of the school, and you say, hey, can you produce this information? When in fact, you have the power to produce the information. Isn't that correct?
Potentially, yes.
Mm-hmm. And eventually, you did produce the information because I asked for it, right? That correct?
I don't know. I don't know.
You don't know.
I don't know who actually ended up providing that documentation.
Yeah. Well, what we do know is that there is an email that he had with ACT, right?
Correct.
And we know that ACT suggested the $350.
I believe so.
Yeah, no, you believe so? Didn't you
From her
get ready for
testimony.
this case and read this stuff?
From her testimony yesterday, yes.
How about the email that got produced that you didn't have when you're cross-examining this gentleman?
That I didn't
Let me
have
show
at
it to
that
you. I'll
time.
show it.
other-
Let me show it to you. Exhibit 18, would you like to review that again? If you look at the second page, you'll find a full paragraph from Mr. Unks from ACT prior to the first COVID test. See that?
Yes, I do.
Said put in $350 for you all, I think is the word, to Mr. James, right?
Correct.
So in this interview, he's trying to tell you, we talked to him, he's trying to tell you, I think there may be, I believe there was an email, and he's telling you the truth, isn't he? Isn't he?
Based on that email, you're asking me to answer based on that email?
Yes, I am.
He provided the 300, I'm sorry,
Yeah.
your
okay.
original question.
Yeah. And then you guys, you and Mr. Batchelder, and there, you talked about his demeanor. Let's talk about yours for a second. Do you agree that in that interview, you and Mr. Batchelder are trying to make him believe he did something wrong?
No.
You're not, really.
I wanted, as I explained to him, an explanation for those payments.
Mm-hmm. He tells you in the interview, I think he says something, if Pat Dubb says he didn't approve this, he's a goddamn liar. Remember that?
I heard that.
You've seen exhibits 13 and 14 in this case, haven't you? State's exhibits, 13 and 14.
Yes.
And you didn't have those either at the time you talked to this gentleman 1 year after he left the office and 3 years approximately after the events, right? You didn't have them.
I don't believe I've seen this one. State's Exhibit 14.
I'm sorry?
If you'll just give me a second. I'm sorry. Okay.
You didn't have either of those emails when you talked to this gentleman for almost 4 hours, right?
Correct.
And you'd have been on the job at that point 1.5 years on your investigation of Mr. James for 1.5 years?
Correct.
here when Mr. Dubs testified yesterday, right?
Yes,
Because I don't dispute these, I just don't remember them, right? You heard that.
correct.
Well, did Mr. Dubs lie to you during your investigation then?
I didn't find anything that Mr. Dubs said to be untrue.
Said he didn't approve it. Didn't he tell you that in your investigation? I didn't approve this.
That's correct.
But then you got 2 emails that says he does. Let's see. Let's talk about Grandma's Gardens for a minute. It was Mr. Byers that brought up Grandma's Gardens to you about some impropriety happening in the August meeting, wasn't it?
He did mention that, yes.
It's in her stuff, but it's, I'm marking XV triple I. Okay. Let me show you, what I'm marking is X, Roman numeral, XV triple
Can you
I.
tell me what the original one is? So
If there isn't one,
There isn't one.
there's not one. This is a new exhibit.
So it's XVI,
XV triple I.
oh,
So that,
XVI.
that's 28.
And Mr. Kirby, what is XVII? All right, go ahead.
Yeah, do you recognize this is a email chain between you and Mr. Byers?
Okay.
Yes?
Yes,
And if you, this always tricks me. They go in reverse when you do these strings, so you have to go to the
Right.
end to start at the beginning. Yeah. So it looks like the first email that's on here is Jim Byers to you on September 6th at 2:26 PM. Is that, am I doing that accurately?
and he has an attachment.
He has forwarded you in that
Right.
email a Ron James to the full board of the August 8th, 22 board minutes. So to interpret it properly, what you have there is Ron James sending the draft of the minutes to the whole board of the prior meeting,
Correct.
probably in anticipation of the next one, that they'll be called upon to approve them, right?
Correct.
Okay. And then what happens is you say to him, thank you, is there anything specific you want to draw my attention to? Right?
Correct.
Because Grandma Garden wasn't on your radar screen.
I don't believe so at that time.
And he says, yes, Ron invited his good friend for us to bid on the horticulture for the event center. I asked him if there was a formal bidding process, and he said we didn't have to. That's his response to you, right?
Correct.
Okay. And then you say, yes, I did see that. You meant from the minutes that were attached?
Correct.
Wasn't sure if the district is required to send out for bids. I believe there's a limit, and that should be outlined in your policies. You should consult your board attorneys for this kind of information as well. That's your response to him, right?
Correct.
To which he responded, this is all taking place on September 6th. You guys are just going back and forth with each other. And he says, yeah, this is an example of the garbage I deal with monthly. Yes, it is in our policy, right?
Correct.
And you say, well, how much was the bid? He doesn't really answer you, does he?
No.
He says, oh, there were no numbers discussed. No, excuse me, I'm sorry. He said, Ron said during the meeting he would give us a, quote, deal, end quote. And you said, so there were no numbers discussed and the board approved a blank check? And he didn't really respond to that either. He just said, I asked Ron if there's to be a vote, and he said no, because it's under $20,000. That was his response to you. You found out that this communication to you is totally inaccurate, didn't you? As to the amount and as to whether there was really a vote,
It-
right?
Whether there was a vote, I don't know. I think the next meeting minutes then, or that was the meeting minutes, it said that they approved it. But I don't know, and you're correct, I couldn't tell if there was an actual vote.
Let me hand you what's been marked.
But the amount was 20,000 he quoted,
That's what he says in this email.
and that's what he said, Ron said during the meeting apparently. But we did look up the policy, if that's what you're asking.
Wait a minute. Wait a minute. What he said to you was, he didn't really answer your question. He said, I asked Ron if there was to be a vote. He said no, because it's under 20,000.
Correct,
He didn't answer you what the policy was. He just said what Ron said,
right,
right?
right. We had to look that policy up.
Let me hand you what I've marked as XVIV, which I take to be, that's not right. What's the number you have? I don't know.
XVI, 3 I's.
The next one would be XIX, correct, Mr. Kirby?
That's right, Judge.
XIX. Trying to remember my
All right.
secretary.
We all agree.
This is-
XIX, Your Honor?
XIX.
Okay, we're gonna make this XIX. XIX. I think that's 29.
No, that's 19.
Oh, that? It's XIF. Let me hand that to you.
I
This
just,
is the next
I just know it from Super Bowls, that's all.
Good, Your Honor. Now, let's be really accurate here. These emails are from Jim Byers to you a year later. Actually, 14 months later approximately, right?
Correct.
We're in November of '23. You've just finished a 4-hour interview of Ron, right? That was October
Correct.
28th or 31st, something like that. And so you write him on November 14th, you say, Dr. Byers, hoping this finds you well and enjoying the fall weather, just tying up a few loose ends on our investigation, right?
Correct.
And so what we know from our prior questions and answers is you don't have any of these emails, the ones with ACT, you don't have the ones with Pat Dubs from Ron James, right? Don't have them.
Correct.
Haven't done that. But you're tying up the loose ends and you say, question, do you recall former Treasurer Ron James disclosing to the school board his personal/professional/business relationship with Doug Reinhardt/Grandma Gardens ? If so, do you recall when and how this was explained to you, right? By the way, before I read his answer, did you know at this point that Dr. Byers had a grudge? He wanted him gone.
He was pretty open about
Pretty
that, I
open
think.
about it. Did you know about the post that he did?
I had
When he, you didn't know that?
No, I had heard, but
He didn't tell you that?
I don't have direct knowledge other than hearing through rumor.
Okay.
Yes.
Well, we turned out the rumor was accurate. He wanted him. He says, Diana, thank you so much for following up with
Sustained.
this. This
I'm gonna
was,
object with regard to Dr. Byers' statements. I'm not sure what it's hearsay. First of all, Dr. Byers was on the stand, could have been cross-examined with
this is
regard to these
impeachment of
statements.
that
He
witness.
wasn't. It's extrinsic evidence of impeachment, which is not admissible.
This is an email with her?
Yes.
It's overruled.
He says, Diana, thank you so much for following up with this. This was done during the September-November board meeting, which we know that to be inaccurate, right? It was done in the August and September
Correct.
board meetings.
Correct.
In our meeting, Ron had Grandma's Gardens owner do a presentation. Ron stated during the meeting, you don't have to do any bids because it's under $25,000. he's going to give us the best price. So he's increased his amount, his memory on what Ron said from one year to the next, right?
Yes.
I asked him if this was a conflict of interest. He said no. He told us in the meeting that he had done business with them for years and that they were the only bid we should look at. We did not vote on this because I would have said no. That's what he wrote you. Now, you had the board minutes. It said he voted when he made that statement to you, didn't you?
It
He
did.
gave them to you a year before.
Again, objection, there's no impeachment here, he testified that he voted on it.
This is the investigator, Mr. Hardman. I'm gonna allow her to answer the question because this is what she's based her investigation on, so answer the question.
So
You
the
knew that
question
wasn't
was-
accurate. Or did you realize that at the time?
That they had voted on it, that they had approved it, yes.
But he's saying he didn't vote. He said there was no vote.
He's saying, correct.
Different than he
There
said
was-
yesterday.
There was question whether there was actually a vote.
He's obviously misrepresented this to you in the course of your investigation, hasn't he?
I think everyone provided their honest recollection of that.
You're gonna let him off the
of
hook?
that. No.
Because the next thing you asked him, also, if you did not vote on the proposal for Grandma's Garden to do the work in the fall of '22, how was it approved? What is the amount of the cap, if any, needed for approval? And as usual, he didn't really answer all your questions. He just said, Ron said no vote required because I was going to vote no. What he said. And you did or did not know he had a grudge at the time of this, November of '23.
I think there were personality conflicts. As I often see in my job.
When did you get the emails with Dubs? When did you get those?
Thursday? Friday?
Last week.
Last week.
And when did you get the emails with ACT on Mr. James?
Same.
Last week?
Same. Correct.
And how did you get those?
Through the prosecutor.
I'm sorry?
Through the prosecutor.
So they know how to do it and you don't?
I'm not sure how to answer that. No?
At about 2 hours and 20 minutes, I'm gonna just test your recollection. Well, you just listened to all this. I bet you listened to it last week too, right? Get ready for the case.
Correct.
Yeah. At 2 hours and 20 minutes and 40 seconds, didn't you and or Mr. Batchelder look at Ron and say, talking about ACT, we've looked back and we can't find anything about his conversations with ACT? Remember that, saying that?
If you're quoting me from that.
I am.
then I'd say yes.
You told him, we've looked back to look for Mr. Dubb's conversations with you or ACT, we can't find anything. You made that statement. Was it true you really looked back?
I wasn't referring to emails.
What were you referring to?
I was referring to the documentation that we had accumulated and interviews we had conducted.
Well, my point
Through
to you is,
information we had already obtained.
I want to know if you were telling him the truth when you said, we really look back for this stuff.
And we had,
Just didn't get it.
just did not have,
Didn't look hard enough. or-
didn't get that information that we
Okay.
needed from the school.
You did tell him, when we talk about attitude and how somebody appeared in it, you did say to him, we can all agree that Janae would have been entitled to more than the direct payment. Do you remember saying that?
I do.
Yeah. And what you know is, she was entitled to it, and she did get it, right?
What I know is she did get it.
Not all she was entitled to, I'm sure Kevin will bring this up. But she got what Mr. Ernst said she could get, right?
I don't know what all was built into the conversation, if he truly understood that Janae was going to be receiving that $350 in the end. I think based on that email, it looked like, if I can say, my observation of that email looked like he was asking for more money for the school for this preparation through COVID or whatever.
That's what an investigator might say, right?
Objection, it's argumentative.
Sustained.
Are you suggesting to the court that this interview was somehow an admission by Ron that he did something really intentionally wrong and broke a criminal law with regard to these ACT payments to his daughter?
Yes,
You are, aren't you?
yes.
I don't have anything else, Judge.
Take a 10-minute break. Okay?
Thank you.
Very close to the price. Yes, I'll discuss. Okay, Conley, so it looks like. Alright, so you charged her. She said she saw this.
Sims, good morning.
Good morning.
You Croach, come on up.
Yes, sir.
What you got this morning?
It's actually an off docket matter, and you've signed the order before.
I did, okay.
For Ricardo, the only issue is he went to go pick it up and they said they needed a detailed description. And so we added that into the
Oh.
order.
So did you do another one?
Yes, sir.
Okay, give me 1 second. Oh, it's, I have right here. The finished motion is to return ceased property.
Yes.
Oh, I got it. Oh, they need more detail order. Okay, no worries. Was this case dismissed?
Yes, sir.
Okay. All right, I got it right here, so I'll sign it right now.
Thank you,
You
Young.
need a certified copy?
No, sir.
Okay, you got it. Fine.
Thank you.
You're welcome.
Now, this is.
Yes, sir.
Good, how are you?
I'm doing well. I don't want to.
Oh, okay, hi, thank you. I'm from Houston,
Ms. Siegler, were you able to look at Collins, the one that Scott Bernstein's case?
Yes, Your Honor.
He's gonna zoom in a minute, I think. Were you able to see what he sent you?
Oh, the text message.
Yes.
Yes, sir. I responded into, we did receive those, but I wanted 3 other things to have a legitimate mitigation
Okay.
to then consider PTI.
And so let me wait till he comes back in. Thank you.
Yes, sir.
Maybe, not a new body. Yeah.
Mr. Bernstein, I don't know if you can hear me, if you're still in the hearing or not.
Yeah, I must say, it's gonna be so hot.
I can see it. Bruce.
Yeah. Yeah. You too. See
All right, Mary. I saw that. I don't know if I heard maybe one of the okay. Perfect. Thank you, ma'am. Do you want to send you an email the day I got the?
Yeah, it's only if it's the office stuff on there.
Okay, then I'll check on it when I get to the office and then I'll send an email confirming.
Perfect.
Thank you.
Yeah, of course. So I would do decision making. Yeah, no, take it.
Oh, I have a pen.
Oh, Mr. Bernstein, can you hear me?
Yes, Judge, I can hear you. I just got out of that summary judgment.
Okay, Ms. Siegler responded to your text. Have you seen her response?
No, I saw she said she received it. Oh, hold on.
Sounds good. I'm just gonna reset. Perfect. Yes.
Is that an official PTI offer? I don't understand the message.
Ms. Siegler,
Yes, Your Honor.
on
So
Collins.
yes, sir. So PTI isn't in our range of punishment. It requires them to do some effort as well, and then we can consider giving PTI. So I gave them the things I would want to see, and then we could do a PTI offer.
Okay. Did you hear that, Mr. Bernstein, that the
Yeah.
state is requesting
So
some
is
information
the-
for your client? Okay.
Just so I understand, you want a PTA, you want her to do the mitigation packet prior to, so we submit all that together?
Correct.
That's correct, Mr. Bernstein.
Okay, well, so Is it a guarantee or is that just, I'm just asking, so.
I think that's so they can consider it, I guess, depending upon what you submit.
I mean, okay, well, if that's gonna be something I don't know.
Well, let me ask you this. You think that is the information the state's requesting? Is that
I just
something?
sent that information. I don't know what else. I guess an apology, I don't know if she should apologize for somebody that wanted to have mutual combat with her and then engaged in that mutual combat. She's enlisted in the National Reserve. She needs to go serve our country. She's never had any priors. Never heard of.
Well,
If she does those requirements, we would do a PTI.
all right.
Was it like a 30-day PTI?
Ms. Brennan, we're not going to negotiate on Zoom, okay? You need to come in person and negotiate. So you've got your information. If you want to talk to the state, you need to talk to them outside of Zoom, okay? Because
Okay.
I don't necessarily want to be a
That's fine.
part of.
Can I
the
get a
negotiation.
week reset?
Yeah, I don't mind giving you a week reset. I just don't want to hear all the.
Jana James and Ron James.
No,
and
not,
ACT.
I'm sorry, not specifically about phone calls, no.
You did not.
Just about the
Because in your
process.
investigation, the one thing that you've really forgotten about in the generic emails that you had Pat Dubs send and in your responsive subpoena to the ACT is, what was going on during COVID? You never asked that question, did you?
To
ACT?
ACT,
Yeah.
just to them, not through conversations.
You asked ACT about COVID years?
If there was anything additional, there was nothing else that they had reimbursed the school. It was strictly, to answer your question directly, no.
The answer's no, so let's do this. I ask you that yes or no question, the answer is simply no. You
Sorry.
didn't inquire with ACT about COVID, right? Correct, yes or no?
Yeah,
No, you did not answer.
no.
Okay. Now, we now know Thursday of last week, you got an email chain from Mr. Onks to Ron and Jana James, right?
Correct.
And that's the email that John showed you, and we've gone through it, and you wouldn't answer his question about the 350. I guess I'm gonna ask it a little more specific. Where did you
Objection
think
to the
that?
statement.
I'll withdraw that question. Let me rephrase the question. Where did you directly think that 350 was going to go?
From conversations I'd had
No,
with
where-
ACT,
Let me back up.
Okay.
Upon reading this email that you got Thursday,
are we talking about,
Which one are you referring to?
Identify
18.
which document you're referring to, Mr.
I will
Hughes.
do that, Judge.
because I don't have that one in front of me. I think you took that back.
18, here, take it. You can give it back to me later.
States 18.
She doesn't have that in front of her, Mr. Hughes.
Thank you.
You got that Thursday last week.
Correct.
All right. Where did you think Mr. Boza was indicating that $350 was to go to?
So based on my reading of this email, July 16, 2020, from Mr. Tim Onks, in that fourth paragraph, he says, "We do understand that there can be additional costs, so we are fine with paying custodial or a rent charge. Typically, those would be okay for up to about $1 per tester or $350 or so for you all."
Okay, so where did you think Tim Ox meant that payment for $350? Who was going to receive the $350 based on that email?
The school.
Okay. Now you've got Exhibit States 13 in front of you that you received last week. Do you have States 13 in front of you?
I do not.
Here. Okay.
Do you want?
Make sure. Come on.
Okay.
13 and 14. You just got those emails. Where did you So this is an email with Pat Dubs, right?
From, on October 29, 2020, 11:52 a.m., from Ron to Pat Dubs and Becca Small.
And these are the ones that Pat Dubs yesterday said, yeah, I approved it, right?
Correct,
When did you get these emails?
same time,
Thursday.
correct.
All right. Now, take those two emails from Mr. Dubs, take Mr. Uck's email. Where do you now think the $350 is supposed to go?
I'm gonna object, it says from Mr. Dubs. These are from Ron James.
Overruled.
Where do you think the $350 is to go?
Mr. James indicates that $350 was received from the school, or for the school. He's referring to a specific ACT check. So they'd received a check at that point.
Who's that $350 belong to?
I can't say who it belongs to.
All right.
I can
Let's
say.
do this game. So, we got email from Ox. I got 2 emails from Dubs. And I got ACT lady yesterday saying that was Jana James money. Now whose $350 is it?
I didn't interpret her to say that was the ACT gal to say that was Jana James' money.
Who did she say it belonged to?
I don't know that she answered that question. I could be wrong.
So you don't think she answered my question, did Jana James deserve this money? You didn't interpret that to be Jana James' money?
I didn't hear you ask that question, that if she deserved that
Well, how
money?
about this? You heard me ask the question, there were 10 checks received by Waynesville schools, cashed by Waynesville schools,
Correct,
and 9 checks paid to Jana James.
correct.
You heard her say, yes, I believe Jana James is owed another $350.
I didn't hear her say that.
Were you in the court?
I was.
Let's talk about those checks. There were 11 checks that the judge brought up, right?
Correct.
In that exhibit 16, do you need that in front of you as well?
I will need that.
Does she?
You can hand her our book, if you'd like.
$16, you said?
Yes, ma'am. There were 11 checks received.
You're talking about the spreadsheet?
Yes, ma'am.
Okay.
Eleven checks.
I have to go.
Did you count them? Let's do this. You heard ACT and the judge ask.
That's what our forensic analysts are for. I will,
Here, I highlighted them.
I have another. Thank you. $11 checks, I see,
11 checks for $350. There were a few other checks
There's-
for other amounts.
for other amounts, 500, correct.
All right. One of those 11 checks for $350 was not deposited. You learned that in your investigation, right?
Correct.
Meaning that 10 checks ultimately were deposited.
Correct.
All right, while you have that in front of you, I guess just to point out another thing. Jana James, after the December of 2021 ACT test, continued to be an ACT test coordinator, correct?
After what day? December?
I'm going to punch you the dates. December 21 of 2021, she continued on as an ACT coordinator.
Correct.
And after December 2021, we agreed that no more checks for $350 were received by Jana James or Wayne local schools.
There was a 22. There were checks to Wayne local, you said,
In
you
the
said
amount
or.
of $350, there's no checks after that December 2021 test.
Yes, I can't. I'm just trying to see what you're seeing. Because those checks ranged from 2020 to 2022.
And we are not here for any of those other checks, are we? We're not here for the $400 check, the $500 check, none of those checks.
There were a couple checks that ACT issued that the school did not receive. So then there were a couple makeup checks for those.
I'm specifically talking about $350 checks that were purchased orders from Wayne local schools for the ACT testing.
They were not all for $350.
We're not here for anything other than $350, are we?
Yes, we're here for the total amount that was issued from ACT to Wayne local schools.
I went to law school, so math is not my best subject, but you
Me-
do this math for me real quick.
Yeah.
9 times 350 is 3150, right? Okay, let's do it, let's make it easy.
I don't have a
All
calculator
right.
or a pen.
What's your question, Mr. Hughes?
Nine times-
I'm not sure.
It's 3150, it's 9 times 350. I'll take judicial notice of that.
Because we know she didn't receive the 10th check. She worked 10 ACT tests as the test coordinator during those COVID years, right?
Okay.
It's your investigation, you
It's-
don't know?
Yes, yes, according to the
Thank you.
ACT, yes, she did.
You believe Dubs was honest in his interview with you? You answered that of Mr. Smith when he asked that question, right?
I believe, yes, I believe he was,
You heard him yesterday say that Jana James earned that $350 and thought that she was entitled to that $350.
I don't know that I, word for word, if that was exactly it, but I believe she well earned extra, I understand. I'm not sure what you're
Based
asking.
on Onk's email, based on your statement that you believe she earned extra money, based on Dub's emails that you got last week, based on what you heard from ACT yesterday, you think she earned that $350 and it is rightfully her money.
I think that is, no, I believe that was, the checks were issued to the school, and that the school had to, had a process in which if a teacher receives an outside supplemental pay, those teachers are on a list, they are approved by the board, those extra payments are all approved by the board. If there was gonna be additional pay for a ACT coordinator, if it was approved by a board, somebody checked off on it and said, fine, based on that, we wouldn't be here.
And that's where you're hung up on, is just, her role is just ACT coordinator, right? Because that's not what ACT is referring to her in the email that you didn't have from Onks, whether it be janitorial services or rent. You're just hung up on that word ACT coordinator, right? That's what you're labeling her. Her only label you is ACT coordinator.
Correct?
Okay. Now, you heard Ms. Jeter say that the ACT coordinator can be the same person that does the additional work and is paid that additional money. You heard that yesterday.
Okay.
Now, did you hear it? Yes or no?
I heard her, I cannot say I heard that specific statement.
Assuming she said that,
Okay.
it broadens what you're interpreting her just to be the ACT coordinator, right?
Okay.
Giving her the right to additional $350 for the additional work that she's putting in for these kids to test, right?
I understand there was additional work.
Okay, so
There may
why,
have been, yes.
why does the school not owe her $350?
Mr. Hughes, this is not, Mr. Hughes, this is not a civil case. The school, I'm not gonna rule on whether the school owes her money. Move on, please. You can take that to small claims.
I'm sure there's gonna be a little bit more than that. Those POs that you read and gone through in your exhibits 1 through 9, state's exhibits 1 through 9, there's no mention in those POs for test ACT coordinator, is there?
Wait. You asked if there's, you said there's no mention of,
ACT coordinator. The purchase orders are not requesting money for ACT coordinator.
actually, the first one does. 1A, the second page, the actual, 1B.
That's not the purchase order.
This is through the system, so this is the requisition order created by Ron James.
You're talking about 1C. Why don't you look at 1C?
I'm sorry, well. So 1C is the purchase order that Ron James created. And it says payment made to WLS VS ACT coordinator.
Versus. That's what VS would mean?
I would believe, yes, but
Indicating it's something different than the ACT test coordinator? Did you ask Ron James that?
when we laid these out in front of him, asking him,
What that label meant?
not that specific.
And did you ask ACT what that meant?
ACT would have no knowledge of the purchase orders from Wayne Local.
Well, did you ask? So you didn't ask him about it?
Correct.
Did ACT, did you ask them if they had any problem during these 10 testing periods to pay the additional $350?
I did not ask, no.
Why would you not?
I'm not sure why I would ask ACT. I'm not sure what you're asking me.
Why would you not? Because the reason you didn't,
Why would I not ask what?
why would you not ask if they had a problem paying $350?
They did not. There was a custodial or rental, or that was their explanation for that additional $350.
Because you left out that very important piece of this thing is you forgot COVID happened, right?
No, I didn't forget COVID happened.
Did you
I don't think anybody
forget
did.
that the testing centers were closed down across the country?
I understand that.
Or did you forget to ask how many testing centers were open during that period?
That wasn't relevant to my,
It's not relevant to
Question.
know they went from 50 kids at max to 310 kids.
I
You didn't ask.
I believe I don't know what to answer. I'm sorry.
It's very, very, very possible that you've made a mistake in your investigation based on the emails you got last week, the testimony of Ms. Jeter, the communication with Mr. Onks, the failure to make a phone call to Mr. Onks, that you've made a mistake and charged her with theft, isn't it?
No.
You're satisfied with your investigation?
I am. I did not know Mr. Onst to be able to call him. I knew the three individuals that I had spoken with at ACT, and they said that Mr. Onks is no longer there. So it would not have been able.
You just learned about Mr. Onks Thursday.
That's my point, right. So having found that, it would have been late for
You're
this
happy with your
purpose.
investigation?
Objection.
In all of the, I'll throw out the question.
So,
In all of the.
Mr. Hughes, hang on, was an objection, please stop.
She asked and answered that, and he withdrew.
Sustain, move on.
With all of the emails now that you have, the communication and emails with Mr. Dubs that you now have, hearing Ms. Jeter testify yesterday, you can't demonstrate that this woman with any level of purpose tried to steal money from Wayne local schools. No.
Objection.
The answer is no.
That's the ultimate conclusion of this. It's a-
Yeah, the court will decide that. She didn't charge them any way that the Warren County Grand Jury did, so let's move on.
In your emails that you received last Thursday, from Mr. Onks, Mr. Dubs, your testimony you heard from Ms. Jeter, in any part of that investigation, did it demonstrate that Wayne local schools expected to receive $350 for those 10 testing periods?
I don't,
The answer is no.
I don't.
Objection.
Mr. Hughes, let her answer.
I don't believe the school knew they were getting the money, aside from Mr. James.
Which means the school also never expected the money, right?
Correct.
Never had the money, right?
Well, the check was issued to the school, the check went into the school account.
Prior to those 10 testing periods and prior to those $350 checks being received by the school had never gotten any money from ACT, ever.
Correct.
No further questions.
Any redirect?
Just one, Mr. James worked on behalf of the school, correct?
Correct.
He was the school treasurer.
Correct.
Objection to leading.
Overruled. Speed this up a little bit.
That's it, no further questions.
Mr. Smith, any other questions?
No.
Mr. Hughes, any other questions? Did you say no?
No.
Ms. Boza, you may step down. Thank you for your time. All right, Mr. Hardman.
We have no other witnesses, we just have to deal with exhibits from.
All right. I show state's exhibits 1 with the all the subsets A through H, 1 through 9 all have, well, then there's a 9 has a G. Any objection to any of those by
No, Judge.
Mr. Hughes?
No.
10, well, 10 through 29, is there any objection to any of those?
We are not offering 21 or 22, I don't think there was any conversation about those two emails.
21.
I would agree.
But we are moving all others.
Okay, other than 21 and 22, not being offered, any objection to any of the others, Mr. Kirby?
No, Judge.
Mr. Hughes? All right, they will all be admitted then without objection. Anything else, Mr. Hardman, you rest?
We do, Your Honor.
All right, Mr. Smith, wish to be heard?
We have a Rule 29 motion for the court. No, and I'll be very brief. Let's deal with the theft and the tampering with records. You have to have a purpose to defraud. You have to have a purpose to, under tampering with records, you have to have a purpose to defraud. Under theft, you have a purpose to deprive the owner of goods or services. That's the school. Everybody, the evidence in this case is irreconcilable with any other conclusion than it wasn't the school's money. Look, like it or not, from an ethics standpoint, what Mr. James really ended up doing was using the school as a custodial depository to get the money to his daughter for her services to ACT, because ACT didn't have a form in their computer program to do it, but they approved it. And ACT intended for her to get the money, Ron intended for her to get the money, she intended to get the money and work for it, and the superintendent approved it. I don't know how anybody can get a theft charge out of that. The tampering with records is nothing more than you did the documents to effectuate this. So there's no purpose to defraud, and the court should grant a Rule 29 motion on those two charges as to Mr. James. With regard to the conflict of interest, the evidence is also undisputed. He did not procure or employ the authority of his office to procure a contract for Grandma's Gardens. And the evidence is, it's a legal argument that he's not a business associate, but I will call the court's attention. I did some more research, which is, pretty good for me. There is a definition of business associate in the Ohio Revised Code. Section 102.031 defines that as a person with whom a member of the General Assembly is conducting a financial transaction. That's the only definition in the Ohio Revised Code for what a business associate is under the conflict of interest public employment contract statute. It has no application to this case. So you have two things. You have, he didn't employ his office, and I said this in the motion that I gave you about the constitutional issue. I don't think you have to reach it. There's no evidence that anybody can conclude that it was Ron James that caused the board to vote for and grant Grandma's Gardens a contract. Wasn't his idea to begin with. He and Dubs were fully aware of the relationship with Grandma's Gardens. He presented it to the board like he should have, and they decided they liked the price and they needed the services, and they contracted it. He can't be found guilty of that. That's my motion.
Thank you. Mr. Hughes?
Thank you. We also making a Rule 29, Judge, just insufficient evidence of any theft of Jana James, and John touched on, obviously, the purpose to deprive the owner, and in Janae's case, it's by deception, that she has to mislead someone with something that is not true. Deception. So, we know she communicated with Dubs about the reopening, test of reopening. Dubs said she deserved the money when he testified yesterday. She communicated with ACT, Mr. Onks, by phone. We know that the investigator didn't check with him. She communicated with Tim Onks by email, which prior to the indictment and only Thursday, the emails were produced. She asked questions at ACT and Andrea Gita of when that first check was late. You got those emails. She emailed the treasurer, her dad, what box to click, and John's right. Because you heard Ms. Jeter, ACT coordinator can only click one box. If she's going to get another check, it has to be a paper check mailed out to the school. She was so deceitful, Judge, in all of this, that she's using her email address of Wayne Local Schools. She's living with the co-conspirator and not text messaging him. They're communicating by email. She's also so deceitful, Judge, that she went to the superintendent and got the thumbs up from him about the test and the knowledge of where this additional check, that was complete sarcasm. I hope you understand that. So we know the ACT didn't feel ripped off. We know the school didn't feel ripped off because they didn't have the money, never expected the money, never thought that they were going to ever get the money. We know that there was additional work required by the ACT, and we know the ACT was paying this additional money. We know that she was the ACT test coordinator pre-COVID, and she was the ACT test coordinator post-COVID, and never got that money. So for the love of her students, she gets charged with felony for getting this school opened up, communicating it the whole time through. So what was her purpose? They have shown absolutely nothing that demonstrates she had a purpose to deprive Wayne Local Schools. She wanted to answer that question, knowing you wouldn't let her. Because the investigator, after receiving the emails on Thursday that she never had, watching the testimony and communicating not properly with Ms. Jeter, she knows there was no purpose or plan or scheme to steal anything. Waynesville lost no money. Still waiting to hear where Waynesville lost money, how they were a victim of anything. Because we've not heard it, because there's no evidence of that. This case just needs to be dismissed, Joe.
Thank you. Mr. Hardman, you wish to respond?
Yeah, briefly, Your Honor, I think obviously it's Rule 29, so it's the evidence taken most favorably to the state of Ohio for the purposes of this Rule 29 motion. It is very clear Ron James represents the school as a treasurer. He received $350 for the school, a check written out to Wayne local schools. That money therefore belongs to the school. I believe the documents, when you really look at these emails between Mr. Ongst and Ron James, Miss James' own comments later about how much money do I ask for building usage shows very clearly that Ron James set this up with ACT or Wayne local schools to receive an extra $350 for building usage, extra supplies that might be needed to get the school ready for COVID. That was what that $350 was for, not for the purpose of the defendant, Jana James. The purpose here is to deprive of money. She clearly deprived, and there is a purpose to deprive the school of $350. They did it by deception, because then what Ron James did, knowledge to Jana James, is they turned around. And first of all, I think the timing is really important here. The first check that went to Jana James, there is no communication with Mr. Dubs at all about that first $350 check. None whatsoever. Nobody's found any. Mr. Dubs testified that he never recalls any communication about it. You see from all of the purchase order and requisition orders that Mr. Dubs had no contact with any of that system whatsoever. It's not until the second check, and even that second check is actually distributed as well to Jana James, before there is even a single email or some kind of communication by Mr. James to try to explain. And I would also suggest to you that the explanation he makes is not truthful. That's the deception. He says, this is just a pass-through. It's supposed to go to Jana for more time that she spends with these kids. Well, you've heard from ACT, they give Jana more money because of the number of kids that are there. It's a sliding scale for how much money she gets as ACT coordinator. You saw from the State's Exhibit 16 the number of additional custodial staff that are at the school that are also receiving money, the number of other individuals who are involved in proctoring these particular exams on all of these individual dates. The evidence shows, when taken in the light most favorable to the state, that the intent behind these payments, I would just note, State's Exhibit 19, Jana James, hey Tim, any news on the ACT payment for our school district? For our school district, her statements. Miss James, what do I bill ACT for building usage? Shows very clearly that both defendants knew this money was intended for the school, and they conceived a plan, Mr. James conceived a plan to direct that money to his daughter because that's what he wanted to do. And he did it by hiding it, by not having it approved, and then by lying about what that money came in for to Mr. Dubs, as demonstrated by the 2 emails, not 9, but 2 emails, when he sent those checks after those checks actually got sent to his daughter. And he also lied on the purchase orders and falsified the purchase orders and requisitions, which are the records that are held in the course of the school district's business. With regard to the third count on Grandma's Gardens payments, I think it's very clear that the defendant was not a neutral observer when it comes to this contract that was entered into between Grandma's Gardens and the school district. You heard from 2 witnesses that indicated at the board meeting, he stated that this is a good Waynesville resident, that he's going to give us a good deal. He's exerting his influence as treasurer upon those individuals. The fact that they approved it or didn't approve it makes no difference to the issue of whether or not he used his influence to get them to do that. That is the crime. And then, as a result, a contract was entered into. I think it's very clear he's a business associate as it relates to, as case law has interpreted that term to mean with regard to an individual who has this kind of relationship. He's making $2,000 a month. He's got an office. at Grandma's Gardens. He signs all of Grandma's checks, or issues all of Grandma's Gardens checks. I mean, this is clearly a business associate relationship contemplated by the statute, contemplated by case law in that definition, and the amount of influence that he used in order to get and obtain that contract is certainly relevant in this particular instance. I would also indicate one of the best pieces of evidence, I think, that indicates Mr. James's influence that was used in order to get Grandma's Gardens this contract, much less earlier ones, was Mr. Reinhardt's own statement when he said, I knew this was the last job I was going to do for Grandma's Gardens. And he was asked why. And he said, well, because Ron's not going to be there anymore. Because Ron was the one that was directing business to Grandma's Gardens and influencing the school district. And that's not appropriate under the law. That is using his influence to obtain that contract and with an individual that he was a business associate. We'd ask the Rule 29 be denied.
Obviously, the court has sat through the testimony the last day and a half. And I will say that as I sat here and listened to each of the witnesses, it became abundantly clear that Dr. Beyer had a personal axe to grind with Mr. James, and to a very large extent that he was the one that was directing the investigation. Out of all of the witnesses that testified yesterday, I found that Mr. Reinhardt was the only credible witness. Superintendent Dubs came across as a lazy superintendent who didn't even know how to operate the system. I found him to be very incredible and his memory to be very selective. It was very clear that the arrangement with ACT that was made in advance was for the additional services that Ms. James was to provide. If they wanted to charge for the building rental, if you look at exhibit number 17, ACT has a drop-down box for payment of the rental of the building. That's not what the payment was for. It was discussed with Mr. Dubs in advance. Mr. Dubs is lazy and his memory was selective. And again, I think he was covering his own butt as he testified here yesterday and throughout the investigation. Very disappointing. And also very disappointing as far as the lack of emails that were not turned over to defense and to the investigator promptly. And I don't know whether that was the state or if that was in fact Dr. Byers that was selectively providing a documentation of these events. There was no theft that occurred. Waynesville never owed the money, was never due the money. That money was always due to Ms. James, so there was no theft that occurred. Your charge is easiest, that's dismissed. Along with that, the count 2 of the theft in office against Mr. James is also dismissed. And count 1, the tampering with records that goes along with the theft, is also dismissed, leaving us only with count 3, having an unlawful interest in a public contract. This statute does not exist for the purposes that says that it does not prohibit public servants from all dealings in which they may have some interest, no matter how remote or above board. It prohibits those dealings in which there is a risk that the private considerations may detract from serving public interest. I really heard no evidence other than Dr. Byers, which I've already told you was completely incredible and had a personal axe to grind with Mr. James. I heard no evidence that Mr. James exerted any influence over the board that voted independently to approve this contract. Again, the contract was brought before the board. There was conflicting testimony as far as who even made the introduction of Mr. Reinhardt to the board. Mr. Reinhardt seemed to indicate that it was the superintendent that introduced him and ran the PowerPoint presentation. So the state has wholly failed in convincing this court. Even if I look at the evidence, I would have to believe that that Dr. Beyer was being truthful in any way, it's just very disappointing. And Ms. Moser, this is no reflection on you, because I think that in your investigation that you were spoon-fed information as Dr. Beyer wanted you to have, and that if you had all the information in advance, that perhaps we wouldn't have been here. The court is certainly in favor eliminating government waste, but this last day and a half has been a waste. That's my rule 29 granted as to all counts. This case is dismissed. Or adjourned.
Who's on Zoom, and we appreciate allowing her to be on Zoom. Destiny, would you state your name for the record, please?
Destiny Cheetah.
Do you have a camera, Destiny?
No, I don't. My screen is shattered.
Okay, I know her voice, Judge. That's her. What we'd like to do
Or
today.
either you're gonna waive,
Yes, Judge.
does
We're
either
waiving-
party have an objection to her not having a camera?
No. Do you object to her not having a camera?
All right, very good. All right, it's gonna be a waiver.
Yes.
Ms. Cheatham,
Yes.
you understand that you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing today and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right. Preliminary examination having been waived, defendants found over to circuit court on a single count.
Judge, we acknowledge the information, waive its reading. My client would stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty. The pretrial will be set for
Before Judge County.
July 8, 2025, 1:30, Judge Conkey.
Thanks, Judge. Judge, we do appreciate allowing my client to appear very soon. Thank you.
No problem. Yes, just one moment. Bond will continue in this matter.
Thank you, Your Honor.
There, we don't have an information.
I can look and pull. Yes, yeah.
Yeah, we'll get an information for you.
Okay, thank you.
Got it.
Call for Mr. Oldham.
Is the PD case?
No.
This flap isn't gonna work. Well, the camera, I gotta flip the camera. I just haven't. And I gotta remember how to do it. Ann was supposed to have this all set, but she didn't. What? By the time you show up. Yeah, need to put a waiver on there. We were trying to do that hours. But, okay, well, hold on one moment. I'm gonna take care of Mr. Bird. Court does call the case, People versus Sean Odom.
And then we have the people, Your Honor.
Good morning, Your Honor. Good morning to your honorable staff. If you please, this court, Brandon Bird, PA 3734, on behalf of Sean Odom. Mr. Odom, can you please state your full name for the record?
Sean Martell Odom. Thank you. You welcome.
If you're today's the date and time set of preliminary examination, at this time, people are unable to proceed as to count one, and as to count two, and the added count three on the amended complaint be remanded to district court.
All right, as to the amended count 3, the domestic violence second offense, you waive formal reading of that charge, counsel, and your client pleads not guilty.
Yes, Your Honor.
All right.
Respectfully.
You need a copy of it?
Right, I never seen the amended complaint, Your Honor. Let's see.
Today?
Yeah.
Oh, no, I'm kidding. Charge? Patience is my number one virtue.
Let's see.
Did you want me to pass it so you can go over that with your client?
Yeah, let me please.
Okay. So I'll pass the matter. We'll take him back, then you can go around and talk to your client. All right, go. And then why don't we put the waiver on the record if we could?
Good morning, Your Honor. And then on behalf of the people, Your Honor, the people will waive any potential conflict between this honorable court and the office of the public defender. While the people don't believe this conflict exists, people make this waiver in avoidance of any doubt.
Your Honor, Lauren Brown, Deputy Chief Public Defender, our office would likewise waive any potential conflicts. We do not believe such conflicts exist in this honorable court hearing these matters. If a conflict were to arise, we'd waive such conflicts so that this honorable court could hear these matters.
And the court for its part also does not believe there's conflict either in Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to either of those matters. We have nothing.
We have nothing.
Really? So no, we have nothing. I depend on you to keep us going.
Waiting to hear back on.
So it's the other people that are causing the problem. Okay. Just threw them right under the bus. What's Warren Green doing? Are you ready?
Very, very.
But you have.
So smooth.
Okay. Mr. Brown, you're looking very dapper, but you don't have anything ready either?
It's a nice suit.
It is. It really is. It really is.
Thank you very much. Thank you.
Yeah. Very fashionable.
I'm not used to all this compliments.
Oh, don't worry. It's gonna last about 5 minutes and then we're back to normal. Miss Mackey, how are you?
I'm good, how are you?
I'm doing well. Wonderful.
So,
Okay, so finally, she's arrived, so things will get going.
well, we have someone.
Miss Willingbrings like, what? All right, we're gonna turn this camera. Well. Uh-huh. I think they did it in. Well, here's the problem. Yeah, something's gonna have to be done, but. Okay. Is it?
Yeah.
What motion?
How does it bid?
Oh, it's got that thing. Okay. We'll. Oh, cutting it. It's. No, I know. Let's not say we did.
So this is just what we would have added anyway. Oh, I see. So you have to.
Uh-oh. Were you all set or you?
Ready, yeah.
Okay. 'Cause you're all set because Mr. Johnson just walked in, so that's trouble. I'm just saying, so everybody better get their things out of the way before he starts. All right, we're gonna bring him back. Don't talk to Warren Green. Court does recall the case. People versus Sean Odom.
Alexander, on behalf of the people, Your Honor.
Yes, Your Honor. Brandon Byrd on behalf of Sean Odom. Mr. Odom, can you state your name for the record again?
Sean Martell Odom. Thank you. You're welcome. All right.
Yes, Your Honor. We did get a chance to discuss this with my client. Understandable. We're gonna wait a formal reading, stand mute.
All right. Court will enter not guilty plea as to that count 3. And maintain his plea of not guilty as to count 2. Count 1 will be dismissed. I'll set a pretrial on counts 2 and 3 for May 28, 2025, 9 a.m. That is Judge Perry at the 15th District Court on the misdemeanor charges. All right.
Permission to address bond, Your Honor.
Figured you would. Go ahead.
Respectfully, we got the misdemeanor that was dropped today. It's the same complaining witness that's on this case that just been dropped to the second. So I'm not sure really how far this case is gonna go, but that's something we'll see in district court. Essentially, my client has been in jail for since March.
Yes, about a month.
About a month. Roughly about a month now. Now it's pushed back almost 2 weeks, Your Honor, for 2 misdemeanors, which essentially could potentially be probationable, or it's almost like he'd be serving a sentence if he stays in jail too much longer. One of these is a 93-day misdemeanor. I understand the other one's up to a year. But respectfully, we're gonna ask for a personal bond in this matter. He understands no contact with the complaining witness. He doesn't want any contact with the complaining witness. My client doesn't want to be sitting in the jail cell like.
Well, he had a personal and then messed that up.
Understandable, Your Honor, but now we're dealing with a whole new set of situations in which my client's been sitting in jail for a month now, almost a month. And I'm pretty sure a month in jail gives you a lot of time to think about where you want to be and where you don't want to be, and how you operate.
On to the people. I want to go back to work.
Severe concerns that he could file court orders. He did pick up that bond violation where he was in contact with the victim while out on bond and had another assaultive incident with her. And in this case, he had an assaultive incident with her and her child, giving the child a black eye. I also think because he's currently on probation in 15 for dealing with this same victim. So I don't believe he can keep himself from being in contact with her, and I have great concerns for her safety and her child's, given the facts of this case and his previous history with numerous dismissed DVs and convictions on DV.
Anything else, Counsel? Respectfully, Your Honor, my client went to he went to the police station. He went to the police station and made a police report in Ann Arbor. That's one of the reasons for the contact.
So just right, but here's what ended up happening. He had a personal bond. He didn't follow the conditions. He then came into custody, was arraigned, and the bond was set at where it is now. As a result of his failure to follow the conditions. And then that is even really outside of the other stuff that the prosecutors indicated regarding the other contacts and other complaints that he has with the victim in the case. What I'm going to do is I'm going to deny your request to reduce his bond. You can take it up with Judge Perry, but at this point, I'll do it that way.
Thank you for hearing me out.
Oh, I'm sorry. Court called case People versus Jalen Kendrick.
Alexander, on behalf of the people, Your Honor.
Oh, boy. Oh, no.
Good morning, Your Honor. Student Attorney Kara Rosengren requesting to practice under Michigan Court Rule 8.120. under the supervision of Assistant Public Defender Hannah Apple on behalf of Mr. Kendrick. Could you say your name?
Taylor Kendrick. So where are you from?
Me?
I know where he's from. I got all that information. I know where Apple's from. Yeah, you.
I attend Cooley Law School, Your Honor.
You do?
Yes.
Oh, a Michigander or you?
Yes.
What part?
I currently reside in Dexter, Your Honor.
So even a Washtenaw County, Michigan.
Yes, Your Honor.
Where are you originally from?
Oakland County, Holly, Michigan.
Yeah, kind of blew it there. Okay. Where'd you go to undergrad?
Western Michigan.
So you just never left the state?
I actually lived in Chicago for 15 years, Your Honor, so.
Did you?
Mm-hmm.
Didn't like it?
Loved it, but came back for my husband's job.
Oh, he's to blame. All right. Permission to practice is granted. Welcome aboard.
Thank you.
Your Honor, today's date and time set for preliminary examination. At this time, people are unable to proceed as to count one. I would ask that count two be remanded to district court.
You're moving to dismiss count one.
Yes, Your Honor.
People being unable to proceed as to count one is dismissed. I'll maintain the defendant's not guilty plea as to count two. Pretrial in this matter will then be set for
Judge Washington.
June 9th, 2025, 9 a.m. That is before Judge Washington. Thank you.
Thank you.
Bond will continue. Thank you. Court does call the case, People versus Quinard Sanders.
Good morning, Your Honor. Alex Warren, Green on behalf of Mr. Sanders. State your name.
Quinard Sanders. I have a plea form in front of me.
Correct, Your Honor. We are going to be proceeding on a guilty plea. Mr. Sanders is currently executing a sentencing judge waiver and the advice of rights form for the court.
All right. Plea form indicates that the defendant will be pleading guilty to an added count two of attempted resisting and obstructing a one-year offense. Upon a successful plea to that charge, count one would be dismissed. There's further the agreement of no delayed or deferred sentencing. That's the court's full understanding of the agreement.
That's our understanding, Your Honor.
Is that correct, counsel? Yes, sir. All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, nothing but the true self you got?
Yes, sir.
State your name.
Quinard Sanders. All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
You understand also that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 1482 District Court. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Yes.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
Wrong.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
I'm sorry.
No.
Has anybody threatened you or forced?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes, Your Honor.
On the date of December 17, 2024, at the location 500 West Cross Street, City of Ypsilanti, Washtenaw County, State of Michigan, did you come into contact with a police officer from the Ypsilanti Police Department?
Yes, sir.
What happened?
He asked me to get in the car and I ran.
I'm sorry?
He asked me to get in the car and I ran.
May I have what do, Your Honor?
Pardon?
Ma'am,
Yeah,
what-
go ahead.
Mr. Sanders, you were approached by a uniformed officer on that date at that location, right?
Yes.
And that officer informed you that he was investigating a crime, right?
Yeah.
And you began walking away, right?
Yep.
And he told you to stop.
Yep.
And you ran.
Yes.
Okay. You knew he was a police officer, right?
Yes.
Okay. You don't dispute that he was acting pursuant to his lawful duties, do you?
Nope.
All right. Your Honor, I believe that lays a factual basis.
As the court complied with the court rule, would it be proper to accept this defendant's plea?
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing will be
May 28th at 10 a.m. on the floor.
May 28, 2025, 10
Yes.
a.m. before Judge Barr.
Yeah.
Bond will continue.
Thank you, Your Honor.
All right, thank you. Thank you, Mr. Sanders. Court does call the case of People versus Stephen Watson. Pardon?
Mr. Watson.
They got him. Oh, we gotta wait.
We're ready in this matter, Your Honor.
Good morning, Your Honor. Katie Rismer speaking for people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Stephen Watson. Mr. Watson, please state your name for the.
Stephen Watson. All right. And what are we doing?
Your Honor, as the court is aware, this time and place scheduled for preliminary examination, people are unable to proceed this morning. I would anticipate a motion to dismiss the felony. I would be seeking a remand on misdemeanor, but I seek the court's guidance as well. It's charged as a DD first, and it should be a DD second. I apologize to the court of counsel that I do not have a complaint prepared, but I could move to add a count 3 of DD second or amend count 2, whatever the court's preference is.
Oh. Can we, Ms. Zenda is like an expert
I mean,
at getting those amended complaints done. And so I think Ms. Zenda might help you out
I
there.
think she's doing the things right now.
Oh, is she? Okay, see? So what I will do then is, and should we do that? I mean, it's my case, so I'll remember, but should we do that as count 3 or just amending count 2?
Just amend.
Count 2, you think will work? Okay. So we'll just amend count 2 to reflect into DV second.
Wonderful. Thank you.
And you're waiving reading on that?
Yes, sir.
And I'll just indicate that we'll maintain his plea to the amended count 2 in this matter of DV second. Count 1 would be dismissed as people are unable to proceed. I'll set a pretrial in this matter for
May 19th at 1 p.m.
May 19th, 2025, 1 p.m. That's before me.
Thank you, Adam. May we address the issue of bond?
Sure.
Honor, my client was out. He had difficulty and I believe there were issues with
positive drops.
With positive testing. My client does have employment. He is hoping that the job is maintained for him, but he does not think it will be maintained for too much longer past today's date. The felony charge was dismissed because there is no complaining witness. I expect there will probably not be a complaining witness at the court date as well. Based on that, Your Honor, I'd ask that my client's bond be returned to its previous state. My client has indicated that he will follow all of the strictures of the court. He has learned the importance of not indulging in drug use during any time period. He's asking that he be allowed to have his bond reinstated. The time he has sat in has taught him a valuable lesson.
The problem is that Yeah, I mean, he was testing positive. That's part of the problem. The other part of the problem is he was supposed to then start CCOP and he didn't appear.
I talked to the agent and working a lot of hours. Told me to come to court and signed up for the CLP or whatever, because I can do intensive outpatient treatment. So, Your Honor, he did have contact. The problem was at the time he was working a lot of hours and he had gone past the time when he should have been reporting. He did speak to the agent. Agent told him to come to court and then he could start getting into the program then. It's not that he doesn't want to. It's not that he intentionally tried to avoid what needs to be done. He set priorities with working and maintaining himself and his family. And that priority, as it turns out, was the incorrect. He has learned then what the priority should be. And again, it's not like he didn't make contact at all. He did do that. He was working. He'd like to continue to maintain that employment.
Okay, I don't need a response from the people. I'm gonna, at this moment, deny your request. I'll look at it again come the 19th. Since it's coming back before me, it's just less than 6 days from now. I'll take a look at it. I would like to see something that's gonna keep him on track, because if he continues to use, doesn't do anything, we're gonna be right back in the same boat. So
I'm not going to use, my job is at risk and I'm for positive drops and I can guarantee that. I'm just trying to get back to work. My job is.
No, I hear you.
Yeah, just like I really learned my lesson. Like, I understand like the importance of not dropping dirty and things like that. And I have learned my lesson. I don't need to be in here. If you give me a chance, I won't let you down. I really just trying to get back to work. And
how many times do you think I hear that?
A lot, Your Honor. A lot. And
so tell me what makes you different.
Because I got 6 kids. I got a lot of things going on, and I'm not a person that constantly gets in trouble. I'm done with the drug use. My system is clean, so you have no problems with that. So if I drop today, drop next week before I come to court, everything could come back the same. And you got my word on that. Like,
so if I were to let you out, if I change my mind and I were to let you out, you test dirty or don't follow anything,
I would do the time in jail. But I'm not
gonna do it right now anyway.
Yeah, but I'm not trying to do that. But what I'm saying is I come back and plead guilty to everything. I'm just really trying to get back to work, and you won't have no problems out of me after today.
You need to get yourself set up with some type of outpatient.
Yeah, and that's what I'm saying. If I go to community corrections today, I can sign up for the intensive outpatient treatment, so I can be able to get on the right track. But there will
tell you what, I'm gonna at this moment deny your request. However, if council would contact community corrections, see what they need, I will consider an order to release him with some strict compliance in their program. And contact community corrections, see if they have something in place for you. Okay. Oh yeah. Please. So I'm not saying no forever, but I'm gonna need something that.
Thank you.
Thank you.
So,
Thank you, Judge.
and after that,
you have to turn off center stage. Huh?
Yeah. Sorry.
Just walk in and start throwing things down? What? No, too easy. Not gonna say anything. Welcome back. All right. So what are we doing? This one? Got him. Okay. Court calls the case, People versus Timothy Stevens.
Alexander, on behalf of the people, Your Honor.
Oh, you're back.
Student Attorney Kara Rosengren, on behalf of Mr. Stevens, Your Honor. State your name.
Timothy Stevens. Your name, sir? Timothy Stevens. Thank you.
In your candidate concept of preliminary examination, at this time, if people are unable to proceed as to counts 1 and 2, we ask that count 3 be remanded to district court.
So you're moving to dismiss counts 1 and 2?
Yes, Your Honor.
Counts 1 and 2 are dismissed. I'll maintain the defendant's not guilty plea as to count 3. Set a pretrial in this matter for
June 5th, before Judge Fleischer.
June 10th, you said? 5th, 2025, 10 a.m. I'm sorry. 10 a.m. before Judge Fleischer. Well,
Thank you.
oh, on continue.
Thank you.
Thank you. She's a lot nicer than you, Apple. I just thought I'd throw that out there. Right? She didn't give me a lot of argument about stuff. Isn't that true? No? Why, man? It's supposed to. No, she's really not.
Oh, whatever.
She's okay. That's it? That's all we have ready? What are all these people doing here now?
Came to see you.
Is that what you just said? Okay. Well, I guess I'll take a break and wait for more to get ready and then come back. She's leaving? Does she have to go with Apple? I like her better.
Okay.
Better?
Well, okay, better may be the inappropriate word. The dismissal, okay. The court does call the case, People versus Deborah Gilmore.
Katie Rosmerski for the people.
Yes, Your Honor. Brandon Bird on behalf of Deborah Gilmore. Ms. Gilmore, can you please state your full name for the record?
Deborah Gilmore.
Morning, Your Honor. People are unable to proceed at this point.
Respectfully request dismissal, Your Honor.
Your Honor, request a remand for this meeting.
People being unable to proceed as to count 1, that is dismissed. I'll maintain the not guilty plea as to count 2. I'll set that for a pretrial on
June 9th at 9 a.m. before Judge Washington.
June 9th, 2025, 9 a.m.
Yes.
9 a.m. before Judge Washington.
Thank you, Judge.
Thank you, Bond. Will continue. Thank you. Okay. That's it. Okay, then I'll stand in recess and you'll let me know when we're ready on other things. So court's in recess.
All right.
Yeah.
Have you seen it? Turn off.
Yeah, come on. Let's go. Do you want me to sit down so you can turn it off?
No. I'm pretty much here every day. I'm just trying to figure out what you're talking about.
That matter on the date of April 1st, 2025.
Yes.
Okay. At some point, were you done testifying?
Yes.
Okay. After you were done testifying, what did you do?
I went and sat back down while they called up the next witness.
Okay. Where did you sit down?
I sat about where I was sitting when I stood up today, maybe one row up.
Okay. So we're making a transcription of this. So I'm going to have to be.
It's on the right-hand side, probably in the third row back.
You're pointing in the courtroom. So you remained in the courtroom?
Yes, I remained in.
Okay. So you sat down in what we would call the gallery of the courtroom on from where you are sitting in the witness stand on the right-hand side. And you said about the third row back.
Third row back.
Okay. And you did that while another witness was testifying. Okay. And at some point in time, did that witness stop testifying?
Yes.
Okay, what happened after that witness stopped testifying?
The judge asked for some more information and then she called for a break.
Okay. The judge showed up to take a break? Okay. Is that a yes?
Yes.
Thank you.
I'm sorry.
It's okay. And what happened when the judge stood up to take a break?
When they called the court for recess, he was on the left-hand side.
Who is he?
Was on the left-hand side. He stood up. He was around two people that had already started to be in the row.
I'm going to just stop you right there. So you've said the left-hand side, that would be the left-hand side of the courtroom from where you are seated in the witness stand today?
Yes.
Okay. That would be the side that the defendants normally sit at?
Yes.
Okay. Where was the defendant seated?
He was in the first row back.
In the gallery?
In the gallery.
Okay, so he was not seated at counsel table?
No.
Okay. So the judge got off the bench and exited the courtroom?
Yes.
Okay.
Yeah, the judge, she did not exit the courtroom right away. She stood up, as they were calling. There was two people up front talking to her. And then when she got done speaking to them, that's when they called the recess. And he stood up.
He being the defendant?
The defendant, yeah. Went towards the middle. There was two people already going to go to exit. He waited until the sound went out.
Okay, when you say how do you know he waited until the sound went out?
Because he turned around and he looked. He stopped.
Objection, speculation.
I'm gonna overrule the objection. I'm gonna let her.
He stopped. He looked back. The minute
Hold on, look back at
the
where?
screen. He looked back at the screen to make sure that the judge.
I'm gonna just,
Okay.
I'll stop you there. We're gonna unpack this a little bit. And Judge, I understand the court's concern. So you observed the defendant. You said he stopped. Where did he physically stop?
In the middle.
In the middle aisle?
In the middle of the aisle.
Okay.
Yeah.
Where was he in the middle of the aisle, close to what we would call the bar or close to the back door of the court?
He was in the middle, like closer towards this side of
Your motion, the right side.
the right side.
Okay.
Yes.
But I'm asking you, distance wise, was he in this area or was he in the back part of
No, he was closer towards
the front? Okay. You are still, fair to say, you are still seated in the third row
still seated.
on the right, your right side of the courtroom.
Yes.
Okay. When the defendant stopped, is he looking at you or is he looking somewhere else?
When he first stopped, he was looking like straight ahead.
Straight ahead.
And then he
And
turned
straight ahead toward, yeah,
towards the exit door.
towards the exit door.
Yes.
Okay.
And then when he stopped, he turned around and he looked.
And in what direction, when he turns around and looks, in what direction is he looking?
He's looking to see if the judge is.
I'm not, and so I'm not asking you. You can testify to things that you see, things that you hear, things that you witness. You can't testify to what someone else is thinking.
Right.
Okay.
No, he
So,
turned in the direction as to where the judge stand is.
okay. So just so we're clear, the defendant was looking towards the back doors of the courtroom. He then turned around and is looking in the direction of where the bench and the TVs are.
Yes.
Okay.
Yes, the bench and the TVs are.
At some point, does he then turn back around to look towards the back door?
Yes, he does.
When did he do that?
The minute the screen started making that sound.
Like a white noise sound?
Yes.
Okay.
Yeah, like
And
it's no longer.
And I will direct your attention
Okay, go ahead.
I'll direct your attention right now. There are screens on in this courtroom. You see those?
Yes.
And they're depicting the court and yourself in the witness stand. Is that correct?
Yes.
Okay. Did the screens look like that when the okay. What did they look like if
They
you look?
were like, as if cable went out, they were, there was nothing there. It said private.
Okay, it said private.
There's a black screen with private written in white.
Yeah,
Okay.
yes.
At that point, once the screens changed from showing the video of the courtroom to this private, what did the defendant do?
He walked on to the right-hand side, stopped to where I was sitting and, made verbal threats.
Okay, he said something to you?
Yes.
What did he say to you?
He called me.
I'm gonna stop you right there.
Yes.
Hold on a moment. You mentioned something, and I just need to clarify this. You said that there was static.
Yes, sir.
What was that you're talking about?
There was no more pictures showing. It was just like when you call up the lawyers to speak to you, the screen makes a noise. It makes it makes a noise. I don't know how to describe it. It's not it's not a silent noise. It makes a noise to where it's not recording anymore. Do you want me to sit down so you can turn it off?
No.
Okay.
I'm pretty much here every day. I'm just trying to figure out what you're talking about. You're saying it made a noise.
Yes, the screen went blank, and it's not like it's crushing out a noise. There's a noise
Coming out of the speakers.
Yes, coming out of the speaker.
Was it a constant noise?
It started, and then I'll be honest, I don't know if it was on.
Gotcha. Okay, just one other thing.
That's fine.
When you said Judge Washington was talking to two people, was she talking to two people in front of the bench or two
Yes.
people behind the bench?
No, two people in front.
So she was speaking to two people in front of the bench. All right. At the point at which she's doing that, can you hear that conversation?
No,
Okay, at the point at which she's doing that, do you hear anything in the courtroom?
no. I mean, I can hear people talk, but not up front. I mean, just what, people may be saying as they're sitting on the gallery.
Right, but do you hear anything else?
No,
Okay. And she had that conversation and turned around and left.
yes, yeah, they call.
At the point that that happened, what was on the screen?
Before, when she got done speaking to them,
Not as she's talking to them.
it's,
What's on the screen?
there's nothing on the screen. And then she got done speaking, then the video came back up before they called recess.
And when you say the video came back up, the video like it is right now?
Yes, and it
Okay.
just showed her on the bench. There was no one on the stand.
Okay, go ahead.
So at some point, as we've discussed, the defendant then turns and is walking, now facing back towards the back door,
Yes.
which would also be in the direction that you are in relation to the defendant.
I think he's just recapping what she's saying, so I'll overrule it. Go ahead.
Yes,
Okay. And you had previously said the defendant said something to you.
yes.
Okay. What did he say to you?
He called me a lying bitch and told me that that he was gonna get even, he was gonna get me. That was the last thing he did. He was gonna get me.
Did you say anything in response to that?
No,
How did that statement by the defendant make you feel?
correct.
After he made that statement to you, where did the defendant go?
He turned around, looked back one more time.
I'm going to stop you there just so we're clear. So the time he's talking to you, is the defendant looking towards the back of the courtroom or the front of the courtroom?
He's looking at me.
Right.
At the exit.
Okay, so he's facing away from where the judge would sit.
Yes.
Okay. After he makes that statement, you said he turns around?
Yes,
Okay. When he turns around, in what direction is he now facing?
he's facing back towards the front where the judge would be sitting for
Okay.
this area.
At the time he turns around, is the judge on the bench?
No,
Okay. If you recall, at the time he turns around, who would be on, and I'm motioning on the other side of the bar, who were there attorneys or people present?
yes, yeah,
Okay.
his lawyer was still on the left-hand side. You guys are still on the right-hand side.
You guys being someone from the prosecutor's office?
Prosecuting,
Okay.
yes. And there was one officer also on the right-hand side, and there was one officer sitting out in the gallery, like 2 up from me.
Okay. So the defendant makes a statement to you. He turns around and he's now facing back in the direction of where the judge would sit. And what happens next?
The minute he saw that his lawyer was coming out, he turned around and took out the exit door.
Okay.
So again, speculation of what my client saw.
Okay. I would agree. So his lawyer, what you saw, ma'am, was his lawyer starting to leave and then he left.
Yeah. the minute
That's
he-
that's what you saw.
Yes,
Okay, thank you. I think that corrects it. That's what.
Go
ahead.
And did you remain seated in the gallery of the courtroom or did you exit the courtroom at that point?
I remain seated.
Okay. And at some point after this fact, did you bring what had happened to someone else's attention?
Yes,
And who was
it
that?
was one of the police officers.
One of the police officers present in the courtroom?
Yes.
Okay. After you made contact with the police officer, did you have any further interactions with the defendant, Mr. Buckner? Okay. Certainly not in the courtroom,
Right,
correct?
right.
Okay. Anything in the hallway of the courthouse?
No,
Okay.
no.
Mayor, one moment, Your Honor.
Ma'am. While you do that, ma'am, you said you were seated in the third row. How far in on that third row were you?
Right there where the gentleman is with the black sweatshirt.
So you were seated on the end
Yes.
toward the aisle.
Yes.
Okay.
I have no further questions, Judge. Thank you.
Cross-examination.
Okay, ma'am, so you were here to testify, and if you remember, was that in case number 25 FB 1106, if you know?
I have no idea.
Did you get a subpoena to come to court to testify in that
No.
case? In that case?
I did not get a subpoena.
Okay.
They asked me to come and testify.
Now, it's my understanding that you're indicating that you are
You're picking
seated
him out. You're picking him out.
in the gallery of the courtroom right here.
Wow. Okay, yeah, gotcha.
Is that correct?
Yes.
And you said that there's a member of law enforcement 2 rows up, sitting right here, where there's an individual with a sheriff's shirt.
Yes.
And your testimony to Mr. Buckner comes down the hall, both aisleway, stands at that same pew where the law enforcement officer was and issues a threat to you, which would have been within 15 feet of the law enforcement officer.
I never said that. I said he stopped at where I was sitting and said something to me. I never at any time said anything that he stopped where the police officer was sitting in the pew.
So when he stopped, he was at your row,
Yes,
but there was still a law enforcement officer 2 rows up.
yes.
Was there other law enforcement officers in the courtroom like there are today?
There's one sitting up in the corner, up here on the right-hand side, where the gentleman is with the glasses.
When any of, I'm sorry.
Sitting where?
The gentleman with the glasses over here?
Mr. Bird?
Yes, that's where the other.
Oh, on this side. On this side?
On this side.
On the right. Okay, go ahead. Go ahead, counsel.
When this statement was allegedly made, none of the law enforcement officers in the courtroom jumped up and said anything?
No.
Now, you indicated that after you testified, you stayed in the courtroom.
Yes.
Was there a sequestration order was there an order that you leave the courtroom after you finished testifying?
No,
Okay, so you heard the testimony after your testimony.
yes,
Mr. Buckner's lawyer at the time challenged the accusations that you made regarding Mr. Buckner, correct?
In which case?
In the case you were there to testify about.
Your Honor, I would object to what that other lawyer did. That would be hearsay.
I'm not asking for
Well,
what,
she's asking, I'll overrule that. I mean, he's not asking what she said. He's just asking what her impression of what he did.
right.
So go.
His lawyer in the case you were there to testify on was challenging you on the assertions, allegations you made about Mr. Buckner.
for that case?
Yes.
Well, I mean, I don't know if he was challenging me, he was just questioning me the same as you are.
And there was another witness that came up to testify after your testimony, correct?
Yes,
You heard that witness's testimony.
yes,
You were there when the preliminary examination ended, correct?
yes,
That Judge Washington, found that there was no probable cause that Mr. Buckner committed a crime. Correct.
I would object to the relevance of that.
Well, Your Honor, the relevance is they've charged my client with intimidating.
I'm going to overrule the objection.
Yep.
Go ahead.
Judge Washington found that there was no probable cause to believe that Mr. Buckner committed a crime after you testified, correct?
she also stated that it can be called back up if they get the proof that they need.
Okay, which is fair. All right. So after you made accusations about Mr. Buckner pointing guns at people, correct?
What does that have to do with this case?
Ma'am, I don't.
Answer the question, ma'am.
Yes, I did.
You made accusations that you saw him deliver crack from a great distance away? You didn't make the accusation? Did you make an accusation that you saw him point a gun at somebody?
Yes.
Okay. No further questions, y'all.
I have no redirect, Judge. Thank you.
All right. Ma'am, how long did it take you to report this to somebody?
Within minutes.
Where was Mr. Buckner when you reported this?
He had walked out of the courtroom.
How long after he walked out of the courtroom did you report it?
Within probably 2 minutes, if even that,
To whom?
to the police officer passing by.
Which police officer? Is that officer here today?
Yes,
Okay, and that's who you reported it to?
yes.
That interaction, and if you look back on the right-hand side where the gentleman seated in the black shirt is, you're saying that's where you were sitting.
Yes,
When Mr. Buckner came down the aisle, you'll notice that the back row is basically a handicap accessible row or a non-handicap accessible row. You see that where it extends out?
yes.
How close was Mr. Buckner to you when he's making these comments?
He was past where the gentleman is sitting with the black sweatshirt, and he was in between that row and the woman sitting right behind him. And he leaned back and
he leaned back.
he was, turned his head back and spoke to me.
So because that's a little bit different than what you told me before, because you're saying that he was where the gentleman seated in the black
Right.
is, he was past him toward the door.
No, right, there's right where he's sitting, right there, at that spot, right there. It's like there's a spot, where you, not where you would enter, but where would be if you're standing beside. So closer towards the opening of the back row.
So he's standing closest to the opening of the back row.
Right, but he's beside where the gentleman is with the black section. And that's right.
But he's over on that side of the courtroom?
Yes,
So ma'am, are you telling me he's no longer in the middle aisle?
No, he crossed from the middle aisle to over to stand closer towards the right-hand side. He's no longer in the middle. He's standing like as if you're having a one-on-one private conversation with somebody.
And how loud were these comments you say he was making?
They were not very, I mean, other people were walking out of the courtroom. I could hear them, but it's not like he was screaming them. They were normal voices.
When you testified in the previous matter, was there a victim's advocate assigned to you?
Yes, there was a victim's advocate.
Okay, so after you testified, did you talk to that victim's advocate?
No. They asked me to just go sit into the courtroom.
I want to go back, ma'am. At the time that you say Mr. Buckner got up, what's on the screens in the courtroom?
The screen was still on to where you could see where the judge was sitting. And then she called for a conference. And then the screen went blank. And then the screen went back up to where you could see where the judge was sitting. And then she called for a recess.
And then what happened to the screen when she called for a recess?
And then the screen went blank. And said, it didn't show any pictures, didn't show any people anymore.
Prior to the judge taking recess, was it Mr. Buckner's other case that was being heard, the case that you were there for?
That case had been heard, and then honestly, as another case was heard, there was a witness, but I think he was sitting out in the galley, and I think that they had started to call for another case. Because I don't think that.
Had your case that you were there on, had it concluded at that point?
Yes, because he was sitting out in the galley.
Okay. So then my question is that case had concluded?
Yes.
The judge had made her ruling?
No, she had asked for some more information, and they had set it aside for a minute and was going to call it back up.
And so had they called another case?
Yes.
Was Mr. Buckner's attorney on that case?
No, he was sitting on the left side, where the gentleman is. He's behind the lawyer right now where the glass is.
So he had moved back to the chair.
Yes.
But during Mr. Buckner's case, he was at the table with Mr. Buckner.
Yes,
From that period in time, that case ending until the judge took a recess, approximately how much time was there? Mr. Buckner, you said was in that first row, right?
yes,
How far into that first row was he?
like right on the end.
So he's right on the end, seated where I guess the young lady in the pink would be.
Yes, I'm sorry.
Sorry to use the people as props, but that's where he was sitting?
Yes,
Okay, so he's sitting right behind his attorney.
yes,
Okay. And then at some point he gets up
yes.
and walks back. Were you the only witness that had testified in that previous case?
No, it was me and one police officer,
Okay.
but I was the only.
Where was the police officer that testified?
He was sitting over, on the right-hand side where the gentleman is with the glasses.
Did he testify before or after you?
After me,
He testified after you.
yes.
Was there another witness then?
They stopped because the judge asked for information. So they were pausing it to see if they could collect the information that was needed to proceed with the case.
So just so I'm clear, you were the first witness to testify, right?
Yes,
The next witness was a police officer.
yes,
And all during that time, Mr. Buckner is at the table where approximately where he is right now.
yes,
Then at some point, there's a break. Mr. Buckner leaves the table and is seated in basically the first seat in the first row behind defense counsel.
yes,
Then another case is called,
yes.
right? And was it the attorneys? Was it the attorneys on that next case? Was that who the judge was talking to?
Yes. I don't know if it was it was someone from the state and then someone representing that person. So yes, that's who the judge was talking to.
They were the attorneys on the next case.
Yes,
Okay, and the judge spoke with them.
yes.
As the judge is speaking with them, what do you hear in the courtroom?
The noise coming from the speaker and
What noise?
the, whatever that noise is. I don't know how to describe it,
Okay,
but just so we can't hear what's being said up here at the back.
okay, so you hear that.
Yes,
At the point that you hear that, where is Mr. Buckner?
still seated.
Okay. The judge then leaves that session, gets up to walk out.
Right, but the screens turned back. When they went back towards their tables, the screens went back to where you could see the judge. And then they called recess.
All right. At the point that they call recess, where is Mr. Buckner?
That's when he stands up, goes towards the middle of it, and then there's two people, he goes, and then that's when he stops. There's two people getting out like in the next row.
How many people were behind Mr. Buckner in the gala?
Honestly, I don't know.
How many people were in, was there a person sitting behind you?
I don't think so.
Was there a person next to you?
No.
Was there a person in front of you? Which would have been in the second aisle?
I don't. If there was, I think.
Didn't ask that. Do you know whether or not, okay, do you know whether there was a person 2 aisles up?
Yes. That's
Who
the
was,
police officer.
and how far over was the police officer? You're saying where the gentleman that just sat down in the blue tie would be? Mr. Warren
No,
Green, that's your.
further over. He's probably where the other officer is, if not closer towards.
So he's further over toward the wall.
Yes.
Is there anybody else in that row that you recall?
No.
Is there any, so where you are, you're saying there's nobody in your row?
Not that I remember, but I'm not that I remember.
Behind you, you're indicating that there's nobody behind you in that row.
Not that I remember.
In front of you, the row would be directly in front of you. There's nobody in that row that you recall.
Not in front of me, there was someone down.
There was what?
There was someone down closer towards like where the gentleman is with the blue tie. There was two people right there.
There were two people right there?
Yeah. They weren't towards the edge, they were like in the middle down.
When Mr. Buckner allegedly makes those comments, do they turn around?
I was not paying attention. I just put my head down and just let it happen.
Council, I know, council approach briefly. This is no too much. There was a. Get some information.
Maybe this witness wants to inquire based on reviewing the video.
Yeah, video also. I don't want this witness excused at this point because I may have questions and the video also may give rise to questions from Mr. Johnson. All right. So we'll pause in this case. You may step down, ma'am. And I'll call you back up. And court's going to take a brief recess. And I know people want to talk to me, but court's going to take.
Mr. and I were hoping to approach.
Yeah, but court take a brief recess.
All rise.
It's also the case of the people versus 5A Mills in that second row.
I'd ask court to.
Exhibit A. In this matter, the court was very specific in questioning Ms. Hudson with regard to where she was at particular times and the like to try to get a sense and feeling as to where Mr. Buckner would have been at any given time. The long and short of it is when I review the video, it is clear Mr. Buckner is not seated in the first seat. He's actually seated in the second row back. And he's sitting there. We can pick up Mr. Buckner and I'm looking at it. When I time what portions of the video, well, let me make this clear. There are points at which when the court goes into recess, there is no video. So in looking at it, the best the court can as to the timing of when the events would have occurred, it is clear we see Mr. Buckner in the courtroom at a particular point. No doubt. He's in that second row sitting there. He's second row, basically second seat in. At the point at which Ms. Hudson indicates that this occurred, Mr. Buckner is not in the courtroom. And that doesn't mean that it may not have occurred at another point. However, the testimony that I have in this case, it couldn't have happened. Mr. Buckner would not have been in the courtroom at that point in time. So with that finding in the court having reviewed that, the court's going to find that there's no probable cause to bind this defendant over on this charge. These charges are dismissed. Thank you. You don't want to take it and keep it?
No, sir.
Yes. Go over. It'll be entered in the system. We'll call over and make sure that just get over to community corrections.
I got to go to the other courthouse, and I got to be there too, so I can just walk across the street.
To do what?
Tether off.
Yeah, you can go over to community corrections. All right. If they give you a problem, tell them to call over to my court, and we'll let them know. All right. Thank you. For Mills. While we're bringing that out, let me have their case, Slaney's case, and the 11 o'clock.
Yes, I'm sorry.
I told them I'd call them. Hang on one second. Court does call the case of the people versus Jillian Carey.
After one, people.
Good morning, Your Honor. Michael Bellotta, on behalf of Jillian Carey, who's present to be in court.
In this matter, record shooters like at a bench conference in this case, so.
That's correct, Your Honor. We spoke at length in chambers about this case and its potential alternative resolutions thereof. So we are requesting an adjournment to June 17th to allow for a time to explore those potential alternatives as well as to have hopefully sufficient time to have expert witness Kevin Parvis testify.
Yes, that's correct, Your Honor.
All right. I will adjourn the preliminary examination then to June 17th, 2025. That's at 12 noon. All right.
Yes,
on that day.
thank you, Your Honor.
All right, thank you. Bond will continue. Thank you.
Yeah.
Court calls the case of the People versus Tybee Mills, 3 cases.
Hindersfield is appearing on behalf of the people.
Good afternoon, Your Honor. Evan Bassan, P71061, on behalf of Mr. Tybee Mills, coming to the podium. Mr. Mills, please state your name for the record.
These are all going to be waivers.
That's correct, Judge.
All right. Mr. Mills, it's correct that you're waiving your right to have a preliminary examination in these matters?
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand that?
Yes, sir.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution of these matters?
Yes, sir.
People also waive their rights.
Yes, Your Honor. Thank you.
Preliminary examination having been waived, defendant is bound over to circuit court on all the felony counts with the misdemeanors following. Counsel, you acknowledge receipt of the information.
I do acknowledge receipt of information, Your Honor.
You waive their reading.
And we do waive a formal reading, Your Honor, this time.
And your client stands mute to this.
And it stands mute, Judge, yes.
All right. Defendant having waived formal reading standing mute, court will enter a not guilty plea. Pretrial in these matters will be set.
June 2nd at 1:30 p.m. with Judge Raul.
June 2nd, 2025, 1:30, Judge Hamoud.
And Judge, I know we just did waive the exam, Judge, but may I briefly address bond, Judge?
You may. Go.
So my client has been in custody since the arrest in this particular matter. I understand that these are serious charges, Judge, but I would also note that my client technically does not have a extensive or criminal history, Judge. His family is in court today. His bond right now is $500,000. Jana, I'm asking for a significant bond reduction. He's been unable to post bond. He was working prior to being incarcerated, Judge. His employment is definitely in jeopardy. Again, Judge, I know one of the charges is a capital offense. But Jana, I'm asking the court to at least consider, if possible, Judge, a $100,000 bond in this particular case, Judge, as opposed to $500,000. I believe that that's still a significant bond to post. If he's able to.
How much did you say?
I'm asking for at least $100,000 as opposed to $500,000.
All right. I'm sorry, I interrupted.
Oh, and so Judge, I just think that that's still a significant bond to post if he's able to post it. But Judge, $500,000 is unattainable at this time, and I also believe that at this time it's excessive given the circumstances, John.
Yeah, the people respectfully request that the bond remains currently set. The most troubling is that there are two. There's an armed robbery, which is a capital offense that people were able to proceed today. We brought in the victim, the Marine Corps from North Carolina. He's present in the courtroom, so that is obviously a capital offense. It did involve in that instance the defendant in possession of a firearm. The oldest case involved a LawNet investigation. It subsequently conducted a search warrant. The defendant was ultimately found in possession of distribution quantities of amphetamine, firearms, as well as 3D printers, items used to make what are commonly called ghost guns, as well as Glock switches to modify the guns. And then when the police went to arrest him on the older warrant, and this was back about 6 weeks ago, the defendant attempted to flee, was in his vehicle, involved in a pursuit involving both the state police as well as Pittsfield Township Police Department, and was again found in possession of a Glock with an extended magazine and more controlled substances. And the search of that yielded other items associated with the modification of firearms to make ghost guns. All of that is both very troubling from a community safety standpoint, as well as the defendant's potential posing a flight risk. So I would ask that bond remains currently set.
Anything else?
Judge, even if the court would impose a tether, Your Honor, or house arrest, just the opportunity to at least post a bond in this case, the $500,000, if it's excessive. And again, Judge, I think even with everything the prosecutor just mentioned, I think $100,000 cash bond is still a significant bond to post, and gives him a huge financial stake in his bond that he wouldn't not comply or be a danger to the community or be a safety risk in any way, shape, or form, Judge.
Well, I would consider the defendant to be a safety risk, given at least the allegations that are contained in is represented by the people in this case. I think that given all of the circumstances, this bond is set appropriately. I will deny the request for a bond modification in this case. You can take it up before Judge Raul.
All right, thank you, Judge.
All right, thank you. Court calls case of the people versus Julian Tabron.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Tabron. Mr. Tabron, state your name.
Julian Tabron.
Sure. I have in this case a plea form that indicates that the defendant will be pleading no contest to an added count 4 of larceny 200 to 1,000, the 1-year offense, and also an added count 5 of breaking and entering illegal entry, a 90-day offense. Upon the successful guilty plea to counts or no contest pleas to counts 4 and 5, counts 1, 2, and 3 would then be dismissed. That's the court's full understanding of the agreement.
It's our full understanding, Your Honor.
Yes, Your Honor.
All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony about to be the truth, nothing but the truth, so help you God?
Yes.
State your name. Julian Tabron.
Put your hand down. Sir, it is this court's understanding that you're going to plead no contest to 2 charges. Is that your understanding?
Yes.
First of all, it's this court's understanding you're going to plead no contest to the charge of larceny 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
The other charge is the charge of breaking and entering illegal entry. That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
2 things about it. I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Mr. Warren Green, the basis for the no contest plea.
Potential civil liability, Your Honor.
All right. Sir, to the charge of larceny, 200 to 1,000, how do you plead?
No contest.
To the charge of breaking and entering, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights in that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No. No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce?
No, Your Honor.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 25395. Any objection to the court having reviewed that report?
None from the defense.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine a defendant's guilt of this offense. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor. There is an additional agreement that I failed to mention earlier. As it relates to restitution, the defense would stipulate to restitution up to the amount of $7,030. Your Honor, there's outstanding property that is going to be returned. We have agreed with the prosecution that property will be returned to the Pittsfield Police Department so that it can make its way back to the owner, and restitution may reduce from that point. But at this point, we stipulate up to the $7,030.
That's a correct statement.
Yes.
All right, just since it's coming to me, I just want to make sure I understand this. The maximum amount is the $730.
7,000.
7,000. $30. As property is returned, that somehow is going to be evaluated and it will come off of that amount.
The laptop, if it's returned, would go there.
Pardon?
I said if the laptop is returned, it would go there.
The laptop is valued at about $1,000, Your Honor, so we anticipate that the people's request will modify to $6,030.
Got it. Okay, so it will not, okay. I just want to make sure I'm clear. It will not go below $6,030, but it won't go higher than the $7,030.
That's our understanding, Your Honor.
With that, all right, so let me. Okay, have I complied with the court ruling?
Yeah.
The defense is satisfied.
Court will accept the defendant's no contest pleas. Counts 4 and 5, counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
June 11th.
June 11th, 2025, 9 a.m. That's before me. Bond in this matter will continue. Thank you. All right, Mr. Tabron, on your way out of the courthouse, on the left-hand side will be my probation department. You can stop in there to start the process. All right? Okay, thank you.
Thank you, Your Honor.
You know what it is? The cameras, yeah, it's gonna have to be flatter somehow, but the problem is that the cameras at the top, not the side.
So my understanding is we're down to the last 3 defendants and we're holding on all.
Holding on all of them? See his phone?
He's part of the problem.
Okay. All right. Thought I'd ask. Okay, who else is?
So this is Ms. Senda and Mr. Bird. We also have Ms. Jana James. The other 2, Ms. Douglas and Mr. Brown, and then,
So, Ms. Douglas and Mr. Brown?
yes.
Oh, that's gonna be funny. No, I'm kidding. All right, well,
And then Ms. Douglas and Mr. Warren.
seems to be a common problem here, Ms. Douglas. No. All right, let's,
Mr. Bird.
is Ms. Zendaya, oh, there she is. All right, let's do that. Get counsel out. How many witnesses?
We need 2 on the Arnold, 1 on the home invasion.
Got it. Court does call the cases of the people versus Devon Gibson.
Alexander on behalf of the people, Your Honor.
Yes, Your Honor, please, Your Honor, report again. Brandon Bird on behalf of Devon Gibson. Gibson, can you please state your full name for the record? Deborah Gibson.
All right, thank you. All right, there are 2 cases here, set for preliminary examination. We're ready to proceed.
Yes, Your Honor. And at this time, the people will be withdrawing their motions for forfeiture by wrongdoing and would be ready to proceed.
All right, very good.
I'm ready to proceed, Your Honor. I do think it's a little preliminary matter that you might want to discuss before taking the record. We won't have, the only complaining witnesses that we have is police. And the people did make me aware that they were trying to introduce a couple 911 calls. So I believe.
Could we approach, Your Honor?
911 calls on what?
Could we approach, Your Honor?
Exhibit 2 through.
And may we publish them to the court, Your Honor?
Yes, sir.
Incident. What happened to Lucinda after she was slammed to the floor?
She lost consciousness. She was just laying there.
Okay. And when you arrived at 8517.
And do they need an ambulance?
No,
It's 1110.
Yes, sir. Yes, ma'am.
Thank you, Your Honor. The people would first call Deputy Gerwig to stand, Your Honor.
Sir, please come forward and be sworn.
Please take a seat, raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so? State and spell your first and last name for the record, please.
Deputy Brian, Carolina.
Good afternoon. Deputy Gerwig, what do you do for a living? And how long have you been employed there?
3 years this year.
And I'd like to direct your attention to March 14th of 2025. Were you working that day? What shift? And were you in a marked patrol car? And were you in uniform? And on that date, were you dispatched to the area of 8517 Cargo Drive? And is that in Ypsilanti, Washtenaw County, Michigan?
Yep.
And what was the nature of that dispatch?
It came out as a domestic incident. Caller was third party, who was the father of a female, saying that his daughter and her boyfriend were getting into the apartment.
Okay. And did you come into contact with anyone on scene? Who?
The caller, well, I identified as caller as just print out.
Okay. And how did he appear to you?
He was upset, visually upset. He did have blood on his forearm.
Okay. And did he want to report an incident to you? And when did this incident occur in relation to the statement he gave to you?
Just almost before, probably 5 to 10.
Okay. And was there anyone else in the residence at this time?
At the time.
Okay. And you said a 911 call was placed?
Correct.
And do you recognize this? And what's contained on this flash drive? And did you review the contents of the flash drive before this hearing? Okay. And did you recognize a voice on that call? Whose voice was it? Your Honor, the people would move to admit people's proposed exhibit 1.
Any objection or voir dire? I think by stipulation here.
Okay.
All right. Exhibit 1 is admitted.
Thank you, Your Honor. Can I plug it in?
Yep.
Okay. Oh, really? Okay.
And what's happening?
I think you should know.
I don't know. Hold on with your daughter. Hold on with your daughter. Is it an apartment over there or is that a house?
No, that's the address, townhouse.
Okay, and when you say she's into it, is it somebody arguing?
But, yeah.
Who's your daughter arguing?
A boyfriend.
Not that many.
Yes, I'm 7 years old.
Because something's been running all over me. Okay, hold on, has somebody that's physically assaulted? Hold on. They assault each other? Yes, ma'am. And do they need an ambulance? No, but you can't even be still fighting my house. Okay. No. Hold on. No. Come on. Has anybody seen your training today? Not very well. I was. What's your name? My name is Fun. We've got to call in, okay? Thank you. Where are they now? Thank you. Where are they now? They're on the road. What is the AOC? Oh, glad you do. How do you spell that last name? What's his first name? Spell that for me. Don't know how old he is. 18 months from now. Is he a white male, black male, Asian, Spanish? Spell on the floor. Say that again. What you need to do is just put you on a call, I told them, here you go.
What, are they on foot or do they have a car?
They're in the car.
What kind of car?
But they're on that one.
Okay, don't turn foot.
Yes.
What's he wearing?
Black shoes, black things, and black and white shoes.
Black and white shoes?
Yes. And she left with him?
Yes, that's, as soon as you on time, I can do this.
And when did she leave?
Routine, a great teacher,
Great teacher.
great teacher. What's wrong with this now?
And she only had a lot of manipulation.
Like, in the 80s, in the
Her name,
we show the person,
spelled that last part.
PRIETD.
Okay. So she welcomed and left with him. Do you know which way they headed or where they're going?
Neither program, I can get dog. So, folks, we do the dog, we get. I'll be in the office.
Will the lock of the dog before police get there?
I'll just do that. I just can't do it anymore. Yeah, well, that's what the dog, he can come in. I'm just kidding. I think. I don't think, I can't do it. He don't make a mistake. I can't do it.
Do you want us to have the answer for your daughter?
Yeah, you don't touch it. Because pick and phone, pick her up, and pick her up and she fell like that.
Sorry, we've got everybody said, when they come back or these change their, when they get their life, it's all over their head.
So going back, you said Lucius wanted to report an incident. What incident did he want to report?
The assault between his daughter and Kevin.
And what did he say happened?
So then picked her up, slammed her in her head.
Yeah, I'm here to say.
In your it's a present sense impression of what he just saw happen after police got there.
Better go loud in. Go ahead.
So he reported, what did he want to report?
Her assault with his daughter and her boyfriend.
And what did he say happened?
That his daughter would send his boyfriend and picked her up and slammed her on the head in the apartment.
And did he say anything else happened?
That they got into it, that he was trying to break them up.
And did he say what happened to Lucinda after she was slammed to the floor?
Said she lost consciousness. She was just laying there.
Okay. And when you arrived at 8517 Cargo Drive, did you take any photos of the scene? Your Honor, may I approach the witness of people's proposed exhibits? I guess I have to change these. 2 through 4.
Yes, you may. Let me just ask this, officer. When you arrived there, who were you speaking with?
I'm seeing, sir.
Pardon?
I was talking to the father, Evan's girlfriend's father. Yes.
All right.
The person I called.
And how did he appear at the time that you?
He was distraught, upset. All right. Trying to tell us what was going on. He had some, what appeared to be blood on his arms.
All right. And that was approximately, I think you said 5 to 10 minutes after the incident had occurred. All right. So just so the record is clear, I'm allowing it either in the present sense impression or as an excited utterance, given that he was under the stress of the situation at the time. So go ahead, Coach.
And may I approach the witness?
You may.
And what did I just hand you?
Picture of the scene of the residence that I took.
And are these a fair and accurate representation of the scene as you observed it on March 14th?
Right.
Your Honor, the people moved to admit exhibits 2 through 4.
Any objection or voir dire?
No objection.
Exhibits 2 through 4, 2, 3, and 4?
Correct, Your Honor.
2, 3, and 4 are admitted.
And may we publish them to the court, Your Honor?
Yes, sir. Thank you, sir. Go ahead.
And do you know Devin Gibson? Is he in the courtroom today?
Yeah.
Can you briefly describe where he's sitting and something he's wearing?
Sitting left, north to the right of you, wearing an orange.
And Your Honor, please let the record reflect that this witness has made an in-court identification of the defendant.
Record shows so reflect without objection.
So during that same shift, at some point, did you find yourself at 8695 Spinnaker Way? And how did you come to be at that address?
A separate caller, in no relation to the original call we were on call, saying that there was a male and female in the locker room that's arguing.
Okay. And what happened when you got to that address?
We made contact with later that Devin and was on.
Okay. And did you interact with Devin when you arrived on scene? And did additional deputies arrive on scene? What other deputies?
Deputy Russell, Sergeant Howe, Deputy Hill.
Okay. And what interaction did you have with the defendant when you arrived?
He was kind of educated. He was in the line with, who was active.
Okay. And did you take any action toward the defendant at this point? What action did you take?
And it was an attempt to detain him pending further investigation.
Okay. And at this time, were you wearing a department issued body worn camera?
Yeah.
And was it activated and recording? If I get one moment, Your Honor.
Yes. Good girl.
Yeah. And do you recognize this?
Yes.
What is this?
This is
And is this a fair and accurate representation of what you saw that day?
yes.
Your Honor, the people would move to admit people's proposed exhibits. It's 2 clips from the body camera. I believe 5 and 6.
Any objection or order? Exhibits 5 and 6 are admitted.
Thank you, Your Honor. May we publish to the court?
Yes.
No, I didn't understand. I understand. I'm being wrong charges. This shit right as hell, bro. No, y'all put me straight, y'all put me straight, bro. I was in the city, help my water finger off, bro. I was in the city, help my water finger off. Why don't you treat me like this, bro? Why don't you treat me like this, bro? Why don't you treat me like this, bro? Why did I do me like this, bro? Why am I like this, bro? I need medical attention, bro. Why is I working like this, bro? Why?
So after you arrested the defendant, what did you do next? And then what happened next?
He began to kick the back passenger door.
Where were you taking him once he was put in the patrol car? Okay, and so what happened when he was being transported?
He kept kicking the back window. Once he kept asking what his charges were gonna be. We advised him that one of the charges was gonna be property from the vehicle because he kicked you on the scene of Spinnaker. He kicked the door so hard, he bent the door off his frame. Once he was advised of that, he said that if he's going to jail for damaging property, he's gonna damage property and kick out the back window.
Okay, and at this time that this occurred, was your in-car camera on at the time? And it was on and activated? And do you recognize this video? What is this?
Our cameras of the users.
And is this a fair and accurate representation of the video that your in-car camera recorded of your patrol vehicle?
Yes.
Your Honor, people would move to admit people's proposed exhibits. I'm sorry, I think I lost count. Were we at
We'd be at 7.
7, 8, 9, 10, 11, and 12?
Okay. Oh, good, you know.
And these would also be in clips, Your Honor.
7, 8, 9, 10, 11, and 12 are.
Thank you, Your Honor.
That's shit weird, bro. So weird as fuck, bro.
Y'all gotta clean that shit. I'll have that shit on with you, I think, too. Real shit. That shit weird as fuck, bro. I just walked in, put a little blood on my face, bro. Y'all gonna take me to jail for a fucking NDOP, bro? Y'all said for one of them, so for the domestic violence, for one of them, resisting arrest. So you wanna, I don't know, y'all don't keep fuck, bro. And you try to bitch, you kick bitch. I know why you don't like me, because you used to cut off my off, and you're a fucking chick, nigga. You're a fucking chick, nigga. You're weird, nigga. But you was the main one twisting my arm and doing that lame ass shit. But y'all gonna be sick as fuck when I'm out tomorrow all that shit, bro. Without that ass fucking wrong, bro. I'm gonna fucking again, bro. That's it, right in the shit, bro. And I gotta, yeah. Let's go get the fuck away, I'm fucked up. Dog, weird ass shit, bro. I'm still putting on my leg, and I got no medal for the shit. Oh. For NDOP? I'll say, do I have NDOP on you? So I got it, right? Yes or no? NDOP. Yes, I told somebody to right out the window there, right? Right? I'll tell you. See, why y'all wanna do stuff like that to me, bro? Why y'all wanna do? I'm gonna jump out. I'm jumping out. I'm jumping out. Yeah, nigga. Yeah, nigga. Why y'all wanna do that to me? Why y'all wanna do that to me, though? Why y'all wanna do that to me? I was way out. Yeah, nigga. Y'all weird as fuck.
And your apologies, it would be, the last one would be exhibit 11, not 12.
11.
Correct. So after this, was your patrol car damaged?
Yes.
Did you get an estimate for the cost of those damages? About how much was that estimate? And did you provide this estimate to the people? Your Honor, may I approach the witness of People's Proposed Exhibit 12?
12. Any objection to 12?
Oh, Judge.
12 is admitted.
And may we publish that to the court, Your Honor?
Yes, sir. Got you calling up.
Your Honor, may I have a moment?
You may.
Thank you. Nothing further from the people.
Cross-examination.
Officer Gerwig,
Yes, sir.
you said Mr. Printup told you that what did Mr. Printup tell you again?
I've seen
When you came on the scene to talk to him?
that his daughter, sorry, the names are real close together. His daughter Lucinda and her boyfriend Devin got into it. So
You said he told you they picked you up and slammed him too, right? Why didn't you put that in your report?
I believe
Would you like to refresh your memory?
I've had it in there.
You say
I said, if you're asking me about it, I take it's probably not in there.
it's not. So why didn't you put it in your report if that's what he told you? That seems like a pretty big detail.
He told this. Or he talked to my partner.
So basically, what he told you was they both were fighting, correct?
Right.
And he never told you who started it, correct? He never, he never said, was my client trying to protect himself or was he the aggressor, correct? You knew there was blood, but you didn't know where it came from.
Right.
He never said that the blood came from his daughter. But that was the assumption, correct? Now, when you came on the scene where Devin was, how many officers were there already?
The second.
Second.
Not the where his dad was, the one.
Right.
Second call.
Second call.
Everybody that was already showed up on the first one, so. Okay, 4 after me.
It was 4 after you
I believe so,
or 4 before you?
after, well, with him.
With you. Okay, so you were one of the first on the scene.
Being my partner, yes.
And was Lucinda there when you came
Which time? Initial,
to arrest Devin?
I believe that was her, yeah.
You believe that was her? So you wouldn't know who Lucinda was if you seen?
Not at the first time, no.
Got you.
So after the investigation,
And how many times have you met Lucinda and Lucius? Print up.
my partner has,
How many times have you met them?
have I met him once before?
You say once before?
Possibly, yes.
When's the last time you talked to Mr. Printup, Lucius Printup?
For this,
Before this court date?
I haven't.
You haven't? When was the last time you talked to him before you were on the scene with him? Before you pulled up on the scene to talk to Mr. Lucius to investigate the situation before you went to go arrest Debbie? When was the last time that you talked to Mr. Printup? You said once before that, correct?
Right.
When?
Said I did.
I said when? When was the last time? You don't understand the time, you don't understand the time frame? I'm asking you, you said, this is what I'm trying to get to. How long have you known Mr. Printup? Because you said you remember his voice. You said you would know his voice.
From the phone call and speaking.
From the phone call and speakers. How would you know his voice from the phone call and speakers from something that happened a month ago? How many other people have you arrested?
That's how I know the voice, which I just told you from the scene, I know his voice from phone calls.
So you got that good of a memory?
I want to talk to him and see if hear a phone call, then it would be correct, yes.
Gotcha. But you forgot to put the body slam in the report.
Is that a question or?
I'm sorry, Young. I'm sorry. That was commentary, Young.
Okay, then I don't need it.
I know, and I apologize. I apologize. Now, when you came on the scene, were you all trying to arrest them? Was it a collaborative effort of all the officers there? Yep, to arrest my client. When you did arrest them, was there, right?
Resisting us, that, yes, all of us did.
Did he assault any officers individually? Did he assault you individually? Did he resist you individually, or were all the officers being resisted?
Resisted myself and my partner.
So he was resisting the collaborative effort that you all were using to try and arrest him. Would that be a correct, accurate statement? Did he ever assault you? I do understand, he did say a negative comment. He did say a negative comment to you.
About my age and descent, that's correct.
He did, and which is reprehensible, but did he ever threaten you because of your age and descent?
Oh, age and descent? No, he never threatened.
Did he ever threaten to damage any property you had because of your age and descent? So it basically was a statement. Out of my client's anger and the excitement of the situation.
A very derogatory statement. Yes.
No, very derogatory. And I'm not going to take that fact from you. I'm sorry that happened.
I get what you're saying. Yes, there was nothing relation between he's saying he's damaging anything of mine because of my age and descent. No.
Got you. All right, no further questions, Jana.
All right, anything else?
I have one moment, Your Honor.
Right.
Just for the people, Your Honor.
All right, you may step down. Thank you. Oh, your next witness.
Thank you, Your Honor. People called Deputy Samaha, Your Honor.
Please come forward and be sworn.
I'm swear to affirm. State spell your first and last name correctly.
First name, Deputy Samaha, spelled D-E-E-N-A, last name spelled S-A-M-A-H.
Give me that again. I'm sorry.
It's my last name?
Yes, please.
Sir. S-A-M-A-H-A.
That was easy. All right. All right, go ahead.
Thank you, Your Honor. Deputy Samaha, what do you do for a living?
I work in the Washington County Sheriff Office.
And how long have you been employed there?
For over 2 years now.
Okay, I'd like to direct your attention to March 14th of 2025. On that date, were you working?
I was.
What shift?
The noon shift.
And were you in a marked patrol car that day?
I was.
Were you in uniform?
I was.
Okay. And during that shift, did you find yourself at 8695 Spinnaker Way?
I did.
And how did you come to be at that address?
The call came out and deputies Hill and Berwick were responding to that address. And I started making my way over there just to back them up.
Okay. And did you come into contact with anyone at that address?
Not at that address. Deputy Berwick at the time gave us the description of the two, male and female, and we went to BOL, which pretty much looked for them in the area.
Okay. And did you find anyone matching those descriptions?
I did.
Okay. And when you went to 8695 Spinnaker Way, was there anyone you came into contact with there? Okay. And when you say Lucinda, who's Lucinda?
So initially when I arrived there, she was, from my knowledge, the victim at the time. She was bleeding from her finger. I had no context whatsoever at that time. I just made my way back to the laundry room where she was, and she was like washing her hands.
Okay. And how did she appear to you?
She was definitely in distress, hysterical, kind of all over the place.
Okay. And what did you do after coming into contact with Lucinda?
I escorted her out of the building and towards my patrol vehicle.
Okay, and when you got to your patrol vehicle, how did she appear then?
She was bleeding from the finger, so we tried to clean her up. Essentially, she was able to carry her own body weight. Then she just kind of started going in and out of consciousness on me. At that time, I had her sit in the back of my patrol vehicle. I had my door open. She was not coherent, was not able to give me any statement. And she, again, just could not carry her own body weight. So at that time, my priority was to stabilize her head so she wouldn't hit it.
Okay, and what happened after that?
We requested HVA and they arrived and they just over.
Okay. Nothing further for this witness, Your Honor.
Cross-examination.
I'm sorry, so, how do I pronounce your name? So I'll get it. Samaha. Nice to meet you.
S-A-M-A. Okay. I got that. Go ahead.
Oh, no, I was about to ask that question. Now, how many officers were there by the time you got to the scene?
When I arrived, there were 4, possibly 5, if I remember correctly.
Got you. And okay. Did you interact with both Mr. Gibson and Ms. Printup or just Ms. Printup?
Just Ms. Printup.
You never seen Mr. Gibson put his hands on Ms. Printup?
No, sir. So I arrived after the fact. I was not there, no.
And you say she was in a hysterical state?
Correct.
Did she ever tell you that my client put his hands on you?
She did not give me a statement, no, sir.
She didn't give you any statement? Did she tell you that he didn't do it? He didn't do anything?
So from what I can recall properly, she did not give me any statement at all. Again, she was kind of in that state of going in and out of consciousness. So I just stopped questioning. We didn't get any further, no statement, no questioning. It was just kind of making sure that she did not hit her head at that point.
Did you see any injuries on her head?
Not on her head, no.
The only injury you seen was on her finger?
She was.
So, is it safe to say you don't know why she was feeling the way she felt, or?
That is correct. I could not tell you what she felt the way that she felt.
All right, thank you. No further questions, yeah.
Can you redirect?
No, Your Honor.
All right. Thank you, Dick.
Thank you, Your Honor.
No further witnesses for the people, Your Honor.
Right.
Witnesses, yeah.
All right. Go ahead.
Next one.
Well, what do you want to do? Well, what do you tell me?
All right, we'll do this.
No, you don't tell me. Go ahead. Do the next case.
Do the next case?
Want to do the bind over on this one?
Please.
Go ahead.
Okay, Your Honor, at this time, the people would motion for bind over. The court heard testimony from Deputy Gerwig saying that when she's reported an incident where the defendant slammed the victim onto the ground, making her hit her head and lose consciousness. The court further heard from Deputy Gerwig that after this event, she had a cut and also was unable to hold up her own body, hold up her head, was incoherent from this injury that she sustained from the defendant. The court further saw body cam footage as well as the in-car footage of the defendant resisting the arrest of the officers, refusing to put his hands behind his back, 10 seconds away, refusing to walk to the car, fighting with officers while he was being arrested. The court also saw in the car the defendant spit on the car multiple times, as well as kicking out the window and causing extensive damage, over $2,000 to that patrol car. So I believe we have met the burden of probable cause in this case to ask the court to bind over.
Response.
Respectfully, Your Honor, when it comes to the assault with intent to great bodily harm, domestic violence, my client, first of all, we don't have any witness to witness it. The only thing we have is tape and the officer statements when the officer statement and the 911 tape in which you could hear him clearly say they both are fighting. We don't know who was the aggressor in that situation. Unfortunately, I can't cross-examine anybody to find out what was going on. We do hear on the phone where he said, he picked her up, my client, picked Ms. Print up and slammed her, but we don't know what that means. I can't cross-examine him and say, how was that? Was she trying to hit him? Did he grab her? And that happened. Was it in self-defense? We don't have any of that in front of us, respectfully, when it comes to the resisting obstructing a police officer, I think we got one resisting obstructing for the most part. In Michigan case law, it has to be an individualized attack on each officer when they charge it in different counts. In this case, this was one situation which a group of officers were attempting to arrest my client. It's not like he kicked one officer, punched another officer. It was one big, and I wouldn't even say it was assault. It wouldn't even go to the assault part, more the resisting part. He was potentially resisting arrest. He was actually frightened, and I wouldn't even call it resisting arrest. He was just frightened. But if we're gonna call it that, he was frightening arrest from multiple officers at the same time. So I would just say that wouldn't be against four different officers. Is one.
You have that case law?
I do, Jan. I'm glad you asked.
All right.
Give me 1 second. I did a lot of research on this case.
Okay. Only does you good if you can find it.
Say
nothing. Yeah.
Oh no, it's it. I wouldn't lie. I wouldn't present.
No, I know. I'm just asking. You need to show it to me.
I know that's right.
Not here.
We do got, is there internet I got on in here?
Pardon?
I need my internet to work.
No. I don't know. Mine's working. So you can't, there's a public access. You should be able to access it.
How to put it on. Usually I got cellular data. But my internet's not my cellular data's not working. Thank you.
This is only one. I can, if I flip it. No. You're not talking to me. The way you're talking. Did you get your internet?
I did, yeah.
Okay, good.
I'm looking for it. I guarantee you I got case law.
Okay. Somebody was. No.
If you go to people rewards, 314 mishap,
314 mishap.
399, 2016.
And what's it say?
It says, the holding is multiple counts of resisting obstructing where appropriate, where the defendant committed distinct acts against multiple officers. Let me see, first two convictions where the conduct was one continuous act that affected multiple officers.
Sounds to me like you said it's appropriate then to charge.
It's not appropriate to charge, Donna, and the ethnic intimidation, you really can't do that because with ethnic intimidation, he didn't do it act because of Mr. Gerwig.
I think actually Deputy Gerwig, he stated accurately, it would not amount to ethnic intimidation.
Right. Now, it was a horrible thing.
Absolutely reprehensible and hurtful and beyond the pale in terms of what another human being should say, but it may not constitute a crime. You're right.
I agree. So I think we only got about one count of resisting obstruction. Resisting obstruction. At the most, no ethnic intimidation, and we don't have witnesses here in which I can cross-examine anything that was being said. The biggest thing we heard is that they both were fighting. That was consistent. That was consistent in the report from Deputy Gerwig. That was consistent in the statement from off of the 911 call. We did also hear that he picked her up and slammed her. Well, we don't know the reasoning behind that, and we don't know what that means. I'm not able to talk to Mr. Printup and say, did he pick her up because she was hitting on him like this and dropped her? I'm not able to do that, Jana. So respectfully, we're asking Actually, we're asking to not bind over all the charges, but I would understand if there is one resisting obstruction charge.
One?
One.
Okay.
One. I understand in the malicious destruction.
At what point are we talking about the resisting obstructor? Are we talking about in the hallway where at least I saw 3 distinct incidents? Are we talking about going down the stairway, which once at the bottom I saw another incident? And or are we talking about at the car when he refused to follow the officer's instruction?
I would call that.
Which resisting and obstructing would you say is the one?
I would say, oh, well, I can't say. I say if anything. That's why I put if anything. But I don't see 3 different distinct acts, Your Honor. I see it all as one continuous act of the police trying to arrest him and put him in the car. That's how I see it. Once they got the cuffs on him, they got him up. He walked down.
Okay. Yeah. I see how you may be looking at it. I think you're wrong, but okay.
Right. That's how I'm looking at it. Respectfully, that's what we asked, you know.
All right. Anything, I don't need any additional argument, but is there an argument from the people? All right, the court, after all of the evidence in the case and seeing the exhibits and the videos, would find that the people have indeed sustained their burden as to the majority of these counts. As it regards count 1, the assault with the intent to commit great bodily harm, less than murder, not only by the statements, but also when Deputy Smaha shows up afterwards, her interaction with Miss Printup buttresses that case of her getting dropped on her head, because first of all, she has a cut. There's the blood that's in the apartment, but then also, as described by Officer Smaha, her inability to carry on a coherent conversation. And as the deputy indicated, she was looking to destabilize her head. It's obvious that something had occurred given the statements that were made. I think that people could show, and that a reasonable fact finder could conclude that there was an assault with intent to do great bodily harm done on Miss Printup by this defendant. So therefore, the court will bind the defendant over on that charge. Count 2, the malicious destruction of fire and police property. I don't think should be any dispute. One can watch the video and see definitely that that's exactly what he did. He did almost $2,500, $2,600 worth of damage to that vehicle in his little fit of rage that he went into. With regard to the resisting and obstructing, as contained in counts 3, 4, 5, and 6, the court, while understanding what the defendant is saying, if it were this one event in there, it could be charged as only or properly found to be only one. But when one looks at the video, one can either do this by officer or the separate events that this defendant engaged in as they are trying to take him into custody. As I indicate, you just need to look at the acts of the defendant and what the officers had to do, because there are some officers that aren't even engaged with the initially, but have to then engage, which he then resists, that are happening in that hallway area or that vestibule area. There is then additional resisting and obstructing as he's coming down the stairway, and other officers have to jump in to try to get him to do that, particularly when he gets outside. He is walking after they've had to carry him down. He then goes into another event where he stops moving, and they have to then move the officer. The officers have to move him. They then finally get him to the vehicle. Sitting there, they're trying to get him to just put himself into the vehicle as they have sat him in the doorway, and he is refusing to do that. And then the officers have to re-engage with this defendant to then put him in. So whether it be by officer or whether it be by event, as the court has laid out, I think the charges of resisting and obstructing, and quite frankly, I think that there could be more, but I will bind the defendant over on 4 counts of resisting and obstructing. With regard to, and I already stated it, with regard to the ethnic intimidation, I think it's one of the most despicable things this defendant could have entered into. Obviously not your finest moment, but also just say shameful as a human being. In particular, shameful is you can roll your eyes all you want, but I'm gonna tell you what, when you can sit there and say that kind of thing, you as a man of color growing up in this country, I don't even know how you get there. Don't know how you get there. But I don't think it fits the crime of ethnic intimidation and won't bind him over on that charge. The defendant is bound over on counts 1 through 6. You know what? You better check your client. Take him back. Bind him over. We'll call the next case up after you check him. Got to finish his arraignment once he's here on the information, but I can't do it at this moment.
Anyway, I can take his file back there with him.
Pardon?
Anyway,
I don't think they're gonna allow him back. I'll leave that to the sheriff's department to do, but if they say no, sir, I can't order them to let that happen. All right. Little. Want me to go on?